So now, perfect, we don't see any concerns. In any case, we're not going to disclose any names or photos of you. We're very concerned about the issues of technology. Okay, without further ado, I pass the floor now to the chair for the first panel on the reconceptualization and transformation of borders in the AI era, Professor Elspeth Guide from Queen Mary.
Thank you. Thank you very much. And Nyovi and Alexandra, you've done an amazing job in putting this together. I'm absolutely fascinated and very honored to be here. I'm not quite sure how I'm going to chair my two online participants. We've got Petra Molnar from York University, from the Refugee Lab, who is online. And we have Amanda Musco-Eklund from Umeå University, who's also online. So I'm hoping that somehow they'll appear somewhere and that we can. Petra's definitely there, do we? Yeah, so she can, yeah, she can start. We can just start. Okay, so we're going to leave the main screen like this. It's a great pleasure to have both of these two speakers online who have done astonishing and very interesting work on the issue of AI and its use in a variety of different areas. Petra and I have been playing tag with one another. We both met up in Toronto last week and said, well, we'll have a proper chance to catch up in London this week. And of course, that isn't going to happen this time, Petra, but next time anyway. I am a great fan of Petra's work, particularly Bots at the Borders, which was one of the first publications looking at this particular issue. Petra, I'll hand over to you. I think we're now down to about 15 minutes per speaker, or else there'll be no time for discussion. So go ahead, Petra, and I'll tell you when you should stop.
Thank you so much for that generous introduction, and a huge thanks to Nyovi and Alexandra and your whole team for putting together such an exciting workshop. Indeed, I'm really sorry that I'm not there in person. I was hoping I would be able to make it, but I am calling in from Boston. But it's a real pleasure to be able to share a few remarks with you. I will keep it brief indeed, and I will also share some photos as I'm speaking. But yes, my name is Petra Molnar. I'm a lawyer and an anthropologist, and the focus of my work is the human impact of surveillance technologies on people crossing borders. And as Elspeth said, I've basically spent the last 5 or so years now tracking how these new technologies of border management, so things like surveillance, automated decision-making, and various experimental projects, how they're playing out in migration control and the impact that they have on people on the move. So today I would like to just share a few reflections from my work on the ground at various border zones, most recently in the occupied West Bank, where I was a few weeks ago with my colleague Florian Schmitz, an investigative journalist. But just a few remarks first about positionality. This is where my anthropology hat comes in. Because when we're trying to document this system of technological oppression, it in and of itself is a risky business, because we are trying to unravel opaque decisions, secretive private sector players, and also witnessing horrific conditions that challenge our common humanity at the border. I mean, just yesterday, 39 people died in Juarez in Mexico in a fire at a migrant holding facility. So how does one carefully and critically document the very real human rights abuses that are in their nature sometimes difficult to see, because technology is a bit hidden in some of these spaces, and yet also very starkly present? And I always ask some bigger questions too, because again, I think as Alexandra said, it's not just about technology. We're asking about the socio-political impacts of these projects. Whose perspectives matter when we talk about innovation, and which priorities take precedence? What does critical and meaningful representation look like, including in photography and storytelling? Representation that foregrounds people's agency, and representation that doesn't contribute to this so-called poverty porn that we often see in representations from conflict zones or forced migration areas. You'll see in my photos, I do not show pictures of people unless we have explicit consent or they're working with us directly in the projects that I run. It's more about trying to capture the feelings when you are in some of these border zones to give a little bit of texture and detail about what is happening. Because it's not my job to try and capture somebody's story in one photograph where they might be at the lowest point of their lives. We see a lot of this in reports and journalism and oftentimes also in academia. So I think it's important to be really critical about the images that we show. And because I'm also a lawyer, I always also like to ask whether human rights framings are enough or whether they also silence systemic and collective nature of a lot of the harms that we are concerned about. Indeed, are we doing enough to open up spaces for abolitionist conversations when it comes to technology at the border? So I think as it's becoming clear to tell this global story of power and violence and innovation and contestation, I rely on the sometimes uneasy mix of anthropology and law. And it's a commitment to a slow and trauma-informed ethnographic methodology, one which requires years of being present in a place in order to try and unravel some of the strands of power and privilege and story and memory that make up these spaces where people's lives unfold. Because indeed, we're talking about spaces where borders kill. They hurt people, and already violent border policies are sharpened through the use of various digital technologies that we'll be discussing together today. These technologies are developed for the purposes of border control and migration management. They separate families, they push people into increasingly life-threatening terrain, and exacerbate historic and systemic discrimination that is already a daily reality for people on the move and other marginalized communities, of course, too. But importantly, borders also serve as a testing ground for new technologies because they're places already where regulation and oversight is deliberately limited, and where we see this kind of commitment to an anything goes frontier attitude that informs the development and deployment of surveillance at the expense of people's lives. So when we're trying to understand the impacts of various migration management and border technologies, things that we'll discuss together, I'm sure, like AI lie detectors, surveillance drones, and various other automated decision-making tools, it's always really important to zoom out and consider the broader ecosystem in which these technologies develop. An ecosystem which is increasingly replete with the criminalization of movement, anti-migrant sentiments, deadly practices like pushbacks that are already leading to thousands of deaths at the border. Because really, at every point in a person's journey, they are already impacted by risky and unregulated technologies to control movement and manage migration. Some spaces like the US-Mexico border, which you're seeing here, have long been spaces where some kind of older surveillance technology has been in the works for a while. But what we were seeing last year when my team and I were there in the Sonora corridor, for example, this is one of the AI towers, fixed towers that sweep the desert, the Sonora desert, in this kind of increasing surveillance dragnet. It is becoming one of those places where more and more surveillance is tested out on people on the move. And in probably one of the most surreal moments of my entire career to date, when we were literally in the middle of the Sonora desert, the Department of Homeland Security announced that they are now proudly going to be unveiling so-called robo-dogs, or these four-legged quadruped machines, which are now joining the global arsenal of border enforcement technology. But of course, what we're really talking about is not just technology. We're talking about the impacts on people. Thousands of people have already perished making the dangerous crossing between US and Mexico, including Mr. Alvarado, who was a young husband and father from Central America, whose memorial site we visited after hours of trekking through the Sonora Desert with a search and rescue group. Mr. Alvarado succumbed to the desert mere kilometers away from a major highway. Because really, oftentimes surveillance and smart borders are presented as the more humane way of managing migration. But they have been proven not to deter people from making dangerous crossings. Instead, what happens, and I would urge you to take a look at some of the work by Jeffrey Boyce and Samuel Chambers in Arizona, for example. What happens instead is people are forced to change their routes towards less inhabited terrain, leading to loss of life. Not only at the US-Mexico border, but as we will get to at the frontiers of Europe too. So really, if these technological experiments continue in the not so distant future, people like Mr. Alvarado might be hunted and pursued by high-speed military-grade technology like the robo-dogs that we saw. I always also like to put up this photo because to me, it's such a stark reminder the absurdity of borders. So this is the infamous Trump wall that bisects the US-Mexico corridor along the Camino El Diablo, or the Devil's Highway that runs along it. You can walk up to it, you can touch it, the rust will stay in your hand for the rest of your day. There's something very violent about the way that it kind of cross-cuts this really beautiful stark landscape, but then it just ends. And you can climb up that hill.
Perché
and
non riesco a connettere, non sento niente di quello che dicono alla Zoom?
Sorry. Yes, you can climb up the hill and kind of poke your head into Mexico. But of course, the US-Mexico corridor is not the only place where violence at the border happens. And I know this photo is a very difficult one, but I always like to show it. For the last few years, I've actually been spending a lot of time in Greece and along the frontiers of Europe. And this is one of the places where people have perished trying to make the journey into the EU. And almost as a pilgrimage, anytime I'm in the Evros region between at the border of Greece and Turkey, I drive down to this little village of Sidero. There's a small cemetery there managed by the local imam of unmarked graves of people on the move who have perished making the dangerous crossing. One of the graves that we saw recently was that of a young woman from Syria who was born in 1993. And there were still decayed roses on her grave. And as I was paying my respects, I noticed something that caught my attention out of the corner of my eye. And I looked and I saw these 3 holes that were gnawed into the earth. There are 3 open graves that wait. So really, this is the region where experimental new surveillance technology is being deployed. For example, Frontex has been piloting various aerostat machines, aerial surveillance. They're very into predictive analytics for trying to figure out people's movement. Border walls have been extended. Sound cannons as well, or long-range acoustic devices for preventing people's movement. And all the while, again, deaths at the border keep being reported. We've also been documenting the rise of these really prison-like refugee camps that dot some of the islands between Greece and Turkey. Kind of as part of an increasingly virtual fortress Europe, such as the one that you're seeing here on the island of Kos in Greece. And interestingly enough, Kos is also the site of an EU-funded project called RoBorder. And as an aside, I'm kind of becoming obsessed with the naming of these projects. You know, we have things like RoBorder, Avatar, iBorder Control. I mean, this is some sort of fantasy dystopia and nomenclature of these projects that I think I need to write a paper on, but I digress. RoBorder explicitly, quote, aims to create a fully functional autonomous border surveillance system with unmanned mobile robots, including aerial, water surveillance, underwater, and ground vehicles. However, I would urge you to think where these resources would be better spent instead of on surveillance technologies. For example, the island of Samos is another site where border violence and technology intersect. I was there for the opening of one of the brand new refugee camps, the first one that opened in September 2021. And it is really replete with all sorts of high-tech interventions. But it's important to note that this camp didn't have running water 2 weeks before it opened. I spent some time with a young mom. She was pushing her little daughter in a stroller on the street, kind of awaiting a forcible transfer into one of these camps the night before. And we were talking about how she was feeling about this move. She hurriedly typed out this message: if we go there, we will go crazy. And it's not hard to understand why, because this is what these new camps look like. I mean, these are images that we've seen many times. We have NATO-grade barbed wire. They're geographically segregated and far away from a lot of urban centers. They're now also filled with algorithmic motion and risk detection services, fingerprint scanners, and even virtual reality glasses that Greek guards are supposed to wear for who knows what reason. So one of the things that's really happening is what we're talking about is a space where these new technologies are being introduced, but we're also talking about profound impacts on people's human rights and civil liberties. Of course, privacy rights are impacted when data is shared with repressive governments, or even when international organizations share information during humanitarian emergencies. Freedom of movement, of course, also, and the non-refoulement principle comes to mind when we are using predictive analytics for purposes of pushbacks or border enforcement, and including one's right to life, liberty, and security of the person. But again, for broader questions too, when and why have we decided that these are the appropriate tools to use, particularly when we know that there is inadequate governance and accountability mechanisms in place for when things go wrong? The context of immigration decision-making really matters because we already know it's incredibly opaque and discretionary. You can have 2 officers take a look at the exact same set of evidence and render two completely different yet equally legally valid decisions. This is how it already operates. So imagine if when we start automating parts or all of these decisions that are very, very high risk. And there's already been human results. People have been deported as a result of wrongful facial recognition. Students were wrongfully deported out of the UK because an algorithm accused them of cheating on a language acquisition test. People are in immigration detention in the US because of algorithmic decision-making. But really, when these drastic events occur, if you are one of the people that's impacted and you want to challenge this, where does responsibility and liability lie? Is it with the designer of the technology? Is it the immigration officer that's deploying it? Is it the algorithm itself? Should an algorithm have legal personality and standing in a court of law? It's really becoming paramount that we try and begin answering some of these questions, because so much of the decision-making related to immigration and refugee decisions sits at this uncomfortable legal nexus where the impact on the rights holder is super significant, even when procedural safeguards are very weak. So really one of the central arguments of the corpus of my work is that this creation of these legal black holes in immigration management technology is deliberate. This lack of governance is deliberate to allow this opacity for technological experimentation to occur that just simply would not be allowed in other spaces. Because mobile populations, people on the move, migrants, refugees, stateless people, they are this kind of abject and feared other, this justification for unregulated technological experiments under the guise of efficiency and security. And it's also, of course, about geopolitics, powerful global north states justifying this experimentation, concentrating this locus of power on other places outside of North America and Europe. Because really, the very rhetoric of migration management or migration control implies that people on the move must be controlled. They are a threat to national sovereignty, particularly in times when more and more states are turning inward and really amplifying this anxiety around movement. So through this kind of spectacle of technology and border control, because oftentimes some of this technology doesn't even work, the state is able to perform in a particular way and show its prowess through these new technological tools. What's really important to note here, and I will conclude shortly, is that we're really, again, talking about a space replete with systemic racism and historical discrimination against people migrating. And technology makes this worse. We know that facial recognition is highly discriminatory towards Black and brown faces. We know that algorithmic decision-making relies on biased data sets which render biased results. And perhaps more specifically, how can a project like an AI lie detector, for example, the iBorder Control project, deal with differences in cross-cultural communication, or the fact that someone might not be comfortable making eye contact with with a person of the opposite gender? Or what about the impact of trauma on memory and the fact that we don't tell stories in a linear way, particularly traumatic stories when we are asked at the border? So really, at the end of the day, this is not really just about technology. It's about broader questions around which communities get to participate in conversation around proposed innovation and which groups become testing grounds for border technology. Why does the private sector time and again get to determine what we innovate on and why? Why are we developing AI lie detectors to be tested out on people on the move and not using AI to root out racism at the border? Those are clear priorities that are set. So in my work, really based on years of on-the-ground research and hundreds of conversations now with people on the move who are at the sharpest edges of these technological experiments, it becomes clear time and again that this current lack of global governance is deliberate because it creates this perfect laboratory for high-risk experimentation, making people on the move a testing ground. Technology replicates power. And unfortunately, the viewpoints of those who are most affected are routinely excluded from these discussions, including academic ones. So we really need to recognize that technology is never neutral. It's always a political exercise where the allure of quick fixes and the hubris of innovation, and also increasingly the lucrative border industrial complex, just simply does not address the systemic and historical reasons why people are marginalized and forced to migrate in the first place. So I will leave it there, and I look forward to hopefully a fulsome discussion. Thank you.
Thank you very much, Petra, for a really excellent kickoff to the workshop today. And I think one of the things I would pick up on is this question of surveillance and the border in the report by Olaf on Frontex complicity in fundamental rights abuses in the Greek and Italian borders. One of the main pieces of evidence which Olaf comes up with was the order by the director of Frontex of the surveillance planes to leave the Aegean, where illegal pushbacks were being carried out, and to start doing surveillance in a part of Italy where absolutely nothing was happening. So surveillance is a double-edged sword. Once you have surveillance, you know people are about to die, and therefore your duty to protect them becomes higher. And I think that there is also another aspect, which is that as people become aware that they are being targeted on the basis of specific behaviors, they change their behaviors, which is also a very human reaction to the AI conundrum. I'll go on now to introduce my second speaker, who is someone I have met fairly recently and I think very highly of, Amanda Mesko-Eklund, who is online. She's at Umeå University. She has had a very interesting career, first as a shipping lawyer in private practice, as a crew member on a rescue ship in the Mediterranean, and she is now theorizing her knowledge and experience in a very, very interesting research project. And I'll hand over to you, Amanda.
Thank you. I will just share my presentation.
15 minutes, please.
Yes, I think I'll be done in even less. Let's see. All right. Can you see a PowerPoint in presentation view now?
Yes, we can. Yes, we can.
Great, perfect. Okay, I would like to start with thanking Naomi and Alexandra for inviting me, and Elspeth for the introduction. My name is Amanda Mesko-Eklund, and as Elspeth mentioned, I originally come from a professional maritime background, and most recently worked for Doctors Without Borders in the Mediterranean as a search and rescue boat driver. And this experience made me change career from maritime to law with the aim to use the law to confront the issues I witnessed. I started working with legal perspectives on automation at the Swedish Defense Research Agency, analyzing autonomous weapon systems. And now I write my PhD thesis on automation of EU border control and its rule of law implications. And I do this at Umeå University up in the forests of North Sweden. And today I will talk about a draft article about operationalizing foreseeability in the opaque context of automated border control and security risk assessments. So the topic of today is autonomous borders and deployment of AI systems for migration management. In my research, I do not focus on AI specifically, but more on the concept of autonomy and the use of technology which is automated. So what does machine autonomy and autonomous systems really means? A simple description is that machine autonomy is intertwined with the concept of human control, which exists on the same conceptual scale. More machine autonomy equals less human control and vice versa. So even a bread toaster could be considered automated, but so far to the end on this conceptual scale that this does not raise issues of rule of law or human control. Much of the technology I look at in border control contexts will be defined as AI, while some will be considered more simple automated systems. And therefore, I find it easier to stick with concepts like automated, because the core rule of law problems I find in my research is related to how a high level of machine autonomy, and therefore less human involvement, challenges principles of rule of law. Now, fundamental rights and rule of law problems related to automation are often discussed as problems of necessity and proportionality. However, I also find fundamental issues in the step before, which is compliance with the basic principle of legality. The principle of legality implies requirements on a certain level of accessibility, foreseeability for interferences in fundamental rights to be in accordance with the law, as required by the EU Charter on Fundamental Rights. Any interferences must be provided for by law. So the principle of legality is basically a safeguard against arbitrariness and opacity in the public exercise of power, which includes requirements on clarity and precision and limits to discretion, which are all connected to the foreseeability of the exercise of power. Now, there is plenty of research regarding how the use of automated systems in general raises challenges for law in relation to foreseeability. But legal requirements on the level of clarity, accessibility, and limits to discretion varies depending on the context. For example, the understanding of legality requirements in a penal law context is different from the understanding of legality requirements in a migration management context, especially where public security interests are involved, which is generally characterized by wide levels of discretion, low foreseeability, and low accessibility. And the current understanding of foreseeability in security and border control stems from a time of solely human decision-making, which relies on the existence of rule of safeguards established over time in a non-automated context. So this understanding of legality requirements cannot be directly translated to the new context of automation. So considering the increased use of automated systems, the aim of this article would be to, let's say, operationalize the rule of law requirement of foreseeability in the context of automated risk assessments in EU external border control. Now, what does this mean? Basically, I will discuss what seems to constitute a sufficient degree of foreseeability in the EU border control regime according to the Court of Justice of the European Union and the EU legislator when the use of algorithms and predetermined risk criteria are used. And this analysis builds on a qualitative analysis of the case law of the court regarding the requirement of foreseeability by comparing cases in an automated and non-automated context, but also by comparing the degree of foreseeability required for automated processing by relevant secondary legislation, such as the EU data protection regime, the amended VIS regulation, and the ETIAS regulation, and then to compare this to how the law deals with risk assessments already in a non-automated context, such as in the Schengen Borders Code. Now, this will then serve as the foundation for a discussion on what implications the required degree of foreseeability has on the compliance with the principle of legality and the rule of law in an automated border context. Now, I will focus on automated risk assessments as one of many technologies, because these clearly illustrate issues related to foreseeability. And also since we're starting to have many concrete examples of their use in an EU context. Risk assessments in border control typically concerns whether one is a threat to public policy, internal security, public health, or the international relations of any of the member states. Now, automated risk assessments usually involves the use of a profiling algorithm, which compare predetermined risk criteria with personal data in order to identify correlations. And as you can imagine, we are getting far from the bread toaster now on the sliding scale between machine autonomy and human control. Previous research has shown how the use of automated risk assessments implies increased opacity, which puts into question the efficiency of traditional rule of law safeguards, such as automated risk assessments under the PNR directive and EU IT systems EFIAS and BIS. Now, all of these examples are risk assessments made before crossing a border, but I will have a wider perspective on risk assessments and border control to also include potentially future automated risk assessments at the actual bordering crossing point, which is an idea not too far-fetched, considering research projects like iBorder control that Petra already mentioned. When it comes to conclusions, this is a too early draft for any final conclusions. However, I have one preliminary observation and one hypothesis to share. The observation is that from my analysis so far of legislation and the court's case law on automated processing of personal data, I believe one can expect quite some unforeseeability, as there seems to be a new logic in this automated context of what can justify a fundamental rights interference. And this is not a person's behavior or any reasonable suspicion that subjects you to the first interference, but simply being a passenger in the case of the PNR directive, or in the case of EFIAS, being a visa-exempt third country national going to the EU. Reasonable suspicion in this risk-based approach is replaced by another trigger for interferences, being who you are in the case of EFIAS, which base risk indicators on data such as education level, age, and occupation, or how you travel in the case of the PNR directive. And to conclude, my hypothesis is that automated risk assessments in border control call for higher levels of foreseeability to maintain rule of law safeguards in the context of automation. According to the Venice Commission, what constitutes a sufficient degree of clarity and foreseeability depends on the nature of the law. And it states that laws dealing with concrete dangers, risk law that is, are allowed to be considerably broader and more imprecise without setting aside the principle of foreseeability. Now, this dilution of legality requirements in areas where certain risk is concerned is accepted by the Venice Commission as legitimate due to, and I quote, the multiplication of the risks resulting in particular from the changing technology. Also, the Court of Justice allows for less effective rule of law safeguards in the context of threats to state security. However, previous research has criticized this kind of precautionary logic, allowing for less strict rule of law safeguards in cases of risk law, since it undermines the rule of law and the principle of legality. Therefore, in light of the opacity challenges coming with the use of automated systems, one could discuss whether automation instead calls for a higher level of foreseeability to maintain rule of law safeguards in the context of automation, precisely due to the changing technology. Now, thank you for listening, and I would be happy to answer any questions later or get feedback. And as this was also a bit of an author's workshop, I would just like to share something I would particularly like feedback on, if there is any. Something I'm particularly struggling with and would like to get feedback on is what I presume is a very common challenge for many when writing articles, which is how do I fit all within the word limit? After all, I'm not writing a book, but this is still a very big topic. So I'm thinking whether it's necessary to compare case law and legislation on automation with its traditional non-automated equivalents, as it basically doubles the material analyzed. And I'm also considering only to analyze case law in depth instead of a secondary legislation. But that was it for me. Thank you very much for listening. We're looking forward to the discussions later.
Thank you. Thank you very much, Amanda, for a very interesting take. And I think having heard you speak before, there are a number of points, particularly about the foreseeability requirement, which really need to be hammered out a bit more thoroughly. And I think that our discussions about the Court of Justice of the European Union judgment in Ligue Droit du Humain a few weeks ago, which Niovi was part of as well, was very interesting, particularly because the court is seeking to try and put the genie back into the bottle, and just very simply stated that machine learning was unlawful. That's it, no machine learning. And that was, of course, an attempt to bring back foreseeability, that you couldn't have your algorithm changing as it's ongoing. But there was another aspect of that judgment that I think we looked at in some depth and definitely needs to be teased out a bit more. And that was the court statement that both direct and indirect discrimination are unlawful. And it strikes me as a very interesting question, whether or not you can actually write an algorithm without including at least some form of indirect discrimination as regards, for instance, place of birth. Anyone here who's from the UK will know if you're born in Belfast or you're born in London, you have a completely different risk assessment. And therefore, all of this context, which results in indirect discrimination, seems to me to be something very difficult to deal with in this new context. Our next speakers are going to be my new colleagues, Dimitri van der Meesch and Gavin Sullivan, who is at the University of Edinburgh, but we have been colleagues and I've known your work for ages and have appreciated it enormously. And I know you only have 15 minutes, but I'm extremely interested to hear what you're going to say. I think you're going to have to come up here, or else the people online aren't going to be able to hear you.
Oh, yeah, you'll edit it. Is that fine, Gavin?
Yeah, that's fine.
Yeah, no, it's all, thank you.
Where can we find the slides?
It should be over here. Others.
Yeah.
Perfect.
Hi, so thanks very much to the organizers for having us. Where would you like to be?
Yeah, I'll be here.
Come here. For having us today, and we're really just here to sketch out some preliminary thoughts on a paper and a broader research project that we're developing that's following a new machine learning infrastructure that the UK Home Office developing called OrderS, which is part of the UK's 2025 border strategy. So this is an advanced risk-based analytics platform that they're co-collaborating with British Aerospace, and it's a key plank of the digital strategy. And the aim of it, the strategy is to quote, and I'm quoting here, improve the UK's ability to detect threats before they reach the border, harnessing the power of technology and innovation. So all incoming and outgoing traveler data, including API, PNR data, and biometric data, will be collected and analyzed in advance of travel and fused together with Home Office data, customs and freight data, watch list data, and other policing and security databases, both in the UK and internationally, and passed to a single window for analysis using advanced analytics risk engines. And the aim, of course, is to enable real-time data sharing and sharing of data-driven insights across government departments to target interventions at or before the border more effectively. I'm quoting there from a strategy document. So our investigation builds on some interviews that we've been doing with both data scientists inside British Aerospace and senior policy managers inside the Office of Security and Counterterrorism in the Home Office, who are responsible for building this machine learning infrastructure. To give you a snapshot of what it does, we will play the promotional video. Okay, so the key tropes of the Cerberus discourse will be familiar to most of us here, freeing up the time of the border officer to do the stuff they love best. We're not particularly interested in those kind of key elements of the discourse. We're much more interested in a different set of questions. Sorry, don't want to watch that again. So one of the key elements that's shaping the study is the relational ontology of data. So that is that algorithms and algorithmic practices are not discrete things with inner logics and bounded properties, but they're complex socio-technical arrangements grasped by the relations that they enact in practice. So we ask, how do machine learning infrastructures for border security like Cerberus work as socio-technical assemblages? And what are the key political and legal stakes for knowing and governing security risks in this way? The second element that's shaping our study is the relationship between law and emergent AI border infrastructures. So legal scholars, as we know, are often talking about how law governs or it ought to govern machine learning infrastructures. That scholarship and the legal debates around it are, of course, important, but we think that they're also missing a key part of the story, and that is that law is not outside of the socio-technical arrangements governing AI systems from afar. They're a co-constitutive element within them. That is, they create the conditions of possibility for algorithmic governance systems to emerge. Law is reshaped through its material entanglement with algorithmic governance systems, and machine learning infrastructures like Cerberus are themselves giving rise to novel forms of distinctive and regulatory ordering that require empirical study. So to capture that, we're using an approach called infralegalities, which explores how AI data infrastructures and legal ordering processes emerge and take shape together by empirically following their interrelations. So our paper also seeks to ask how law is being reconfigured through AI bordering infrastructures like Cerberus. And today, we're just going to talk about a relatively small piece of that larger problem. And that is, how is the development of advanced machine learning infrastructures like Cerberus enabled and constrained by legal norms? Specifically, how are recent ECJ decisions on the legality of processing of PNR translated into technical use cases for the development of AI bordering infrastructures like Cerberus? What are the institutional, socio-technical, and regulatory processes involved in this translation and assembling of a digital bordering capability? And what are the key questions that we ought to be asking as we're empirically studying this infrastructure development in motion?
Great, thank you. What we're specifically looking at, so one way in which to understand the role of law, or how law is this, as Gavin was saying, co-constitutive element in these data infrastructures at the border, is we are looking at the impact of decision-making and court cases around PNR data in the post-Brexit context and the UK's data problem that it gives rise to. So the key here to start from is that a system like Cerberus, or basically any kind of risk assessment engine that Amanda was so interestingly speaking about before, or inherently data-hungry systems. Now, of course, in the post-Brexit landscape, the data that the UK could rely on as an EU member state, and this is not only in relation to PNR, but maybe for the UK more problematically, all the Schengen information system data, is no longer accessible as it was before. And now at this point of data sharing, we see, of course, a particular legal regime kicking into place. So we see the entry point of legal norms and standards into this kind of construction of the digital border in a very particular way. So post-Brexit, obviously, the UK comes under the third country legal regime, and specifically we look there at the CGU opinion 115, in relation, which is a decision on the PNR data exchange between the EU and Canada. And what we want to argue, and what I'm sort of briefly going to hint at, is that what we might be seeing here is a kind of infrastructural Brussels effect. So a way in which norms emanating from the European legal order, let's say the PNR-based legal order, have an extraterritorial effect. So we use the term Brussels effect with Anu Bradford. I'm sure many of you will be familiar with it, but that does not really manifest itself on the level of legislation change in the UK, but that this has an impact on infrastructural design. So the team that Gavin was speaking about that we're trying to interview and follow within the UK Home Office consists of both tech developers, but also data protection specialists. And the collaboration between these two groups of people is precisely, it finds its origin in this very particular legal moment when EU legal standards become relevant in the context of data sharing. And so the TCA, the Trade and Cooperation Agreement with the EU and the UK, is quite interesting in that sense, because you really see here a process of norm diffusion where the explicit language of the Court of Justice of the European Union in Opinion 115 has been explicitly adopted in the post-Brexit arrangement between the EU and the UK. And so we find that explicit language in relation to the use of special categories of personal data and non-discrimination, in relation to principles of purpose limitation and human review. So also elements that Amanda was speaking about in relation to the rule of law. And most particularly for our inquiry here, because we are thinking about algorithmic or automated decision-making and the use of AI, all the elements that are related to the automated processing of data. So the models have to be specific and reliable. They have to be pre-established models and criteria, which, as Elsbeth said, also what came out in the Ligue des droits humains by the CGU would basically make machine learning kind of tenuous or impossible, although I think we can have a conversation about the extent to which that's really the case. And it has to be grafted on a reasonable suspicion of who can be seen as a high-risk target. So here we basically see how this language has been explicitly adopted in the TCA. So we have terms on reasonable suspicion, on the need for specific and reliable pre-established models and criteria. And this is all language that comes, quote unquote, from CGU 115. Now, one very interesting element in the context of AI and the Home Office is the problem of data retention. So because the UK post-Brexit falls under the third country regime, it is subject to the language of CGU 115, which is that there needs to be an objective evidence from which it can be inferred that certain passengers pose a risk in terms of terrorism and serious crime in order for that data to be retained by the UK. But of course, the very process of data retention is essential for the development of AI-based models, right? These AI-based models require these large pools of retained data in order to find patterns and learn inferences. So the loss of access for the UK to this enormous amount of retained data would pose a serious problem for AI development. And on the basis of that, the UK was able to negotiate a derogation based on special circumstances. Now, we arrived there at a quote that kind of summarizes the infrastructural Brussels effect that we want to point to. So what we see here is the paragraph from the TCA, where the UK pledges to delete PNR data unless there is objective evidence that certain passengers pose a risk in terms of the fight against terrorism and serious crime, which is again the language of CGU 115. But there are special circumstances where the UK can derogate from that for a period of 2 to 3 years. And the reason for that derogation is based on special circumstances. And Mr. Jones, who was interviewed by the House of Lords in the UK, explained these in the following terms. As a third country, the EU is now required to treat us as a third country, and therefore the CGU opinion in respect to EU-Canada applies. At the moment, our technical systems are not set up in a way that can fully comply with requirements of this agreement. And now, of course, we see the origin of why these people have come together in our empirical work, why you now see this needed collaboration in practices of socio-technical design between, on the one hand, data protection people, and then on the other hand, the system design people. And this is what we describe as the infrastructural Brussels effect, and seeing how via the TCA, the CGU has now actually become a sort of standard that the infrastructural design of Cerberus has to live up to.
Okay, so just to close, we'll just raise a few questions. And I guess the key argument that we're making here is that Cerberus isn't just driven by a desire for building a digital bordering capability built on real-time risk assessment at scale. It's also a socio-technical design process, both for overcoming the limitations of the legacy IT projects within the Home Office, and also for translating legal norms, including from the TCA and the ECJ's opinion 1/15, into a complex machine learning infrastructure, ordering infrastructure. And we want to just close by highlighting a few issues and questions that we're asking that's kind of coming out of our interviews that we're hoping to guide our empirical study on this going forward. Firstly, how is the tension between large-scale algorithmic analysis of PNR data over time, which, as Dimitri said, requires data analysis and retention, and specific time limit analysis to determine risk after departure? How is that being addressed in practice, and what are its productive effects? So, and as one of our interviewees put it, previously the UK Home Office kept PNR for 5 years, and that was because they wanted to undertake what they called historical analysis with maximum contextualization. So while, and I'll just leave the quote there too, I won't go through that for want of time, but the key point is that the Home Office and BAE staff are acutely aware of the need to comply with the TCA in order to get access to the data. But they believe that the TCA fundamentally misunderstands the capabilities and affordances of risk-based predictive analytics and targeting techniques, and that the TCA is primarily orientated towards a much more rudimentary form of PNR data analysis that some of the EU states are undertaking, where they're specifically matching PNR against watch list data to identify as already known threats and not using it to do rule-based targeting or predictive analytics to spot as yet unknown threats. That was a quote from one of the interviewees. The PNR data might not be read today, but if all you're saying is I can look at it once and once only, then you'll be giving me no ability to contextualize beyond what I can see right now. The TCA was not written by a data analyst because a data analyst would have said, if we delete the data just because someone is green today, it doesn't mean they'll be green tomorrow. Secondly, given that the UK's PNR analytics system was previously geared towards large-scale data mining and historical analysis, the incorporation of these legal norms into Cerberus is also generating new socio-technical regulatory ordering techniques for governing risk at the border. For example, Cerberus system designers are currently building risk indicators and selection criteria for PNR data deletion. So from what we understand, this risk criteria are composed of up to 15 risk characteristics from which risk can be inferred. Quote, so when we see a passenger who has exhibited this criteria or doesn't exhibit this criteria and they've departed the country on this date, that's when the trigger for deletion through all the separate products within the Cerberus system has to happen. So how these risk indicators and criteria are generated and how machine learning tools help to operationalize and shape that criteria to infer risk are questions that we're particularly interested to explore, because they are effectively constituting a novel form of opaque algorithmic risk-based governance that's quite distinct from the rules-based targeting that the Home Office has previously done in relation to PNR data. And one of the likely effects of these norms requiring risk to be governed on the basis of objective criteria is that their operationalization will require more data to be collected and greater reliance on machine learning techniques for algorithmic pattern detection, not less. And that's why TCA compliance has now become an added-on business requirement for the successful delivery of the Cerberus machine learning infrastructure. We're wrapping up now, and I guess there's much more to be said here, and I'll just briefly summarize this slide. I guess the third reconfiguration that we're looking at here is to what extent is the development of this type of infrastructure reassembling the state? And primarily, empirically, we're looking at the shifting relations between BAE and the Home Office around the development of this program, the interinstitutional relations between different government departments, because different data structuring, formatting, and sharing processes are needed to make that data algorithm ready, as Tarleton Gillespie puts it. And to what extent is this Cerberus program and its affordances also moving to reshape the UK and EU's relationship post-Brexit? So yeah, these are some of the questions that we're looking to explore, and be really happy to get your feedback on that as we're just starting on this process. Thanks. Yeah.
Thank you so much, and I'll give you that page back as well. Thank you so much for a really interesting presentation. It's been really interesting research. The only thing I would say to you immediately is watch out for this latest decision from the Court of Justice, because the court has held that the private sector cannot use data protection exceptions, which are available to the public sector, but are bound by the general data protection regulation exceptions only. So BAE, although it's sitting in the same room and working with the Home Office, is subject to a completely different set of data protection rules and obligations on deletion than the Home Office itself. And how this system is ever going to be designed in a way that will fulfill this particular aspect of the Court of Justice's judgment, so there can be access to EU data, strikes me as a bit of a nightmare for somebody. But our next and last speaker on my panel, and I know we're running over, but we'll run over and the coffee break will be abolished, and I'll leave it to Niovi to solve the rest of the problem, is Niovi herself, who's done some of the most astonishing work in this field, has written the volume on the subject, and is leading this whole project. Niovi, I'll hand over to you.
Thank you so much. Thank you so much, Elspeth, for the very kind words. And as a former supervisor, I wouldn't have done anything without your support in the past. So because this is a work in progress, I don't have slides, and it is a very conscious choice because a lot of the things that I'm going to share are going to probably change over time whilst I develop this article for the project. So the title, the tentative title of the article is Revisiting Informatization of the Body in the AI Era when the Foreigner is the Border. So the aim is to identify how AI technologies have impacted informatization of the body and what the expanded possibilities for informatization entail for the embodiment of the border by the foreigner themselves. So whilst I am an EU law scholar by training, I hope to do a presentation, an article which of a little bit of a broader perspectives, drawing from different jurisdictions. So starting from a theoretical standpoint, Balibar explains that the border is different in each instance and in every experience of border crossing, that to cross one border is not the same as to cross another, and that to cross with one passport is not the same as to cross with another. So for Balibar, this singularity of the border, its differential existence, makes it nearly impossible to define the border, since what definition would be capable of holding together these differences? So the borders can be different between states at different moments of history and in relation to different people. So a universalizing ontology of borders per se seems impossible. So this is a bedrock of this contribution, aiming to demonstrate that the proliferation of AI-based systems and instances of informatization of the body really make the border experience and basically unique for each foreigner themselves, and it affects how they experience the border. So it builds on previous, obviously, observations about the transformation of borders, which are shifting both inwards with border procedures and outwards through externalization processes. They've become digital, virtual, and biometric. They are being parallelized with a fence or a fortress. And Moreno-Lax, in her conceptualization of the evolution of the integrated border management, she refers to this widening of the border through digitalization, the thickening through militarization, and the externalization through outsourcing of border control, in order to denote this embodied paradigm of border, which becomes immanent, continuous, and omnipresent. So indeed, digitalization is central in this omnipresence of the border. It is a process of extracting and aggregating from body, whereby bodies are translated into information, which are then becoming legible, comparable, identifiable, and predictable. So there are virtual data doubles that figure as notions that can be governed. I focus particularly not on digitalization in general, but on concepts in relation to informatization of the body, which basically the big elephant in the room is the biometric systems and biometric technology in order to informatize the body. So already since 2005, Irma van der Plegh was talking about informatization, associated informatization with prerogatives of tracking movement and correct identification of the foreigner on the move. And she was explaining there quite eloquently that the translation of so many aspects of bodily existence into digital data, codes, and information undermines the neat division between the body itself as belonging to material reality exclusively, whereas the digital data derived from that body being the mere representations which are thought to belong to a fundamentally separate domain. So at the heart of informatization lies the extraction and digital representation of physiological features unique to an individual, like friction reads, or in other words, fingerprints, pattern of the iris, retina, the veins of the hand, physiognomic features, shape of the hands, or voice patterns through biometric technology, which involves the collection with a sensoring device and the creation of these digital representations, which are then transformed via some algorithm to produce a so-called template. So obviously, I think that we all understand what are the attractions of biometrics, is that the body is thought to provide an objective and incontrovertible source of truth about a person's identity. It results from the presumed unchangeable, unalienable, and unique nature of the individual biometric features, which are completely opposed to tokens or passwords or documents that can be lost or forged or copied. In other words, the body doesn't lie. So this wider use of biometrics is based on a substantial performance improvements, including through algorithmic and AI-based tools. So how this evolution of the processing of biometric identifiers has taken place? Obviously, the fingerprinting has become a routine exercise for almost now 3 decades, for around 3 decades. And it takes place not only by public authorities, but increasingly also by international organizations. The UNHCR is quite known for processing fingerprints, as well as iris scans or facial recognition technology. But in the past few years, we see a distinct shift in processing also facial images. And I have already discussed in another contribution how large-scale IT systems, for instance, in the EU, are being prepared for future facial recognition technology, and what challenges this poses regarding data protection rules, for instance, with regard to the principle of data accuracy. What are the inherent limitations of facial recognition with regards to biases? And there I second to what Petra mentioned earlier about the biases of facial recognition technology in respect of Black and brown people, and particularly women. And what is a particular of interest is the potential of a facial image becoming the border for the foreigner, or even the passport for the foreigner. In the case, for instance, of the UK, the forthcoming establishment of the electronic travel authorization system, which is the equivalent of VESTA or the forthcoming ETIAS in the UK, it's expected to operate also on the basis of latest facial recognition technology to create a contactless digital border. So facial recognition technology is going to make contactless corridors possible, and would require international travel to submit biographic and biometric details before they fly in order to make it possible to travel easily. However, facial recognition technology is not going to apply solely at the actual border crossing point, but it is bound to be used beforehand. So quite a dystopian scenario is that facial recognition is going to enable the authorities, the border authorities, to clear individuals at the borders before even they come to the border guard. For instance, the Schengen information system hints towards the possibility of capturing the facial image of the individual before they even reach the border, so that it is compared by the system beforehand, and the border guard knows whether the individual should enter or not. But also in the EU, in the context of interoperability, we know that borders are going to be faced by individuals also on the national territory after they have entered. So the notorious Article 20 of the interoperability regulations refers to the Common Identity Repository, which is going to be the yellow pages encompassing the basic biometric and biographical data of almost the entirety of third country nationals. And it is going to, part of how the Common Identity Repository is going to be used is to enable police authorities to conduct live checks on the basis of biometrics in the presence of the person there, which means that processes such as the very much contested smart devices that Greek authorities have already introduced on national territory in 2021 are going to become very much legitimized with interoperability. And it is a project which has already been criticized quite a lot. The Greek Data Protection Authority has already issued an investigation in that regard. So we see that the border is going to be faced by the foreigner before they arrive, when they are at the border, and afterwards on national territory. But we know also from a very recent publication by Frontex on the future of travel, I would say the dystopian future of travel, but they don't say that, new tools of facial recognition and personal identification technology are being tested, including thermal imaging and AI technology to enable facial recognition in the dark, feature extraction models using convolutional neural networks, and for facial recognition also of partial images. So we can expect that in the future, facial recognition technology will entail that the foreigner may find the border also on other occasions and when they think that they are not being seen. However, facial recognition technology is not the only biometric feature, biometric identifier that AI technology has enabled its operationalization. We see, for instance, a distinct shift towards voice speech recognition, which is a biometric modality that uses input from an individual's voice to identify that person or verify their identity claims. And voice speech recognition is currently in its infancy. Daria Oskul from the AFAR project has done an exceptional work in mapping relevant AI technologies in Europe and has explained how dialect recognition has been used since 2017 in Germany in relation to asylum applications. So how does this relate with the border? Well, recent reports actually demonstrate that the future of the border control may include a biometric passport check and voice recognition, whereby a visa applicant during the application process would read a reference sentence and provide the sample of their voice. When then the travelers would read the same sample sentence, the system would compare and verify the voice data at the border. So it is going to be a verification of the voice at the border. So we see how voice recognition can be used for the individual to experience the border based on their own data. What are the challenges? Many, from a technical perspective, we can think of a series of challenges in relation to background noises, weak microphones during the enrollment stage, but also there have been significant concerns regarding the reliability of such tools. Even in Germany, there is a full evaluation pending on this tool, but the recent data demonstrate that the reliability of the tool is between 70 to 85%. So we see a very wide degree of errors in voice recognition. And obviously, depending on how what is the quality and the quantity of the training data, they're going to increase the recognition and accuracy rates in voice recognition, because if the training data does not include dialects of a language from a specific region, then the software may misrecognize the dialects from those regions. So a series of challenges for that for individuals. And finally, even though biometric systems per se focus primarily on fingerprints, facial images, to very little extent on iris recognition, and now all the more on face recognition, it would be a mistake not to discuss how emotion recognition is actually based on biometrics as well. So the burst of interest in AI has also created the expectation that AI systems can help infer a person's inner emotional state based on the examination of facial expressions, often in conjunction with other physiognomic characteristics, such as their posture, their voice, their heart rate, and body temperature, and then sort them into discrete categories like angry, happy, or afraid. So here the key difference and distinction to be made is between facial recognition technology and facial analysis, which is part of how emotional recognition is taking place. Obviously, this is a technology that has been heavily criticized. Dimitri has written an excellent article in that regard, other colleagues, with emphasis on the notorious eye border control research program. But in general, to summarize, this is considered to be, to a large extent, pseudoscience. There is not even agreement on what the emotions are and how these should be defined. My contribution, I intend to build a bit on the reliability of biometrics-based emotion recognition, also to explain that here, as opposed to other biometric identifiers, we have a difference in the interference with privacy. So whereas facial recognition and fingerprints may entail an interference with privacy from the perspective of bodily integrity and informational privacy, with emotion recognition based on biometrics, we also have an additional dimension of privacy being interfered, privacy of emotions and of thoughts. So we have that additional dimension that I intend to focus. So that's the impact on informatization of the body based on AI technology. But the last part of this contribution aims to bring an additional dimension to to the impact of AI. So artificial intelligence has been possible because of informatization of the body and identification in general, but it has also become a necessity because of the amounts of data collected, which cannot otherwise now be processed. So it is the result of the identification, but it is also become a necessity. And it is based on data. It is based on data in order to create, to do the training of the data, to create statistical data, which means that in addition to the impact on the individual who experience the border themselves based on their own data, we have AI having a more broader impact, whereby each foreigner becomes the border for the other foreigners as well, because their data are the basis of training data that create the algorithms, and therefore this is the key difference that AI brings. And the individual is not only the border for themselves, they become also the border for others. So I don't have much more time, so I will conclude by saying that Phil Douglas, the Director General of the UK Border Force, has stated that in the future, you won't need a passport, you'll need biometrics. So this contribution will demonstrate precisely that, how essentially the passport will become a secondary document, because the biometrics are going to define who is excluded, who is included, and how the border is essentially embodied by each migrant and foreigner themselves. So thank you so much.
You made me think of an anecdote of about 20 years ago, when Steve Jobs and the president of the Chrysler Corporation were on a talk show together. And Steve Jobs was saying, well, you know, we're making these amazing new computers and the programs, and our failure rate is about 5%. And the president of the Chrysler Corporation said, if we had a 5% failure rate in the cars we built, we would be out of business. So I think one of the difficulties we have in this field is an acceptance of the false positives, etc., at rates which are completely unacceptable in any other field of either public policy or private sector activity. You can't have this kind of a failure rate, which our techies consider should be normal. We are at the end, but I assume we have some time for questions.
11 minutes for sure, and maybe a little more.
11 minutes for sure. Okay. Now, I was the discussant, and as I've been going along, I've been providing each of the presenters with a few clues about where I think you might want to be going in respect of the ways in which you're looking at the question. So what I'd like to do is open the floor up to everyone else at this point for your comments. I would make one final one to Njovi, which is on this voice recognition number. I mean, Frontex itself has told us that a border guard has 12 seconds to make a decision. How long is it going to take to read out these little statements and do the voice recognition? And that the reason a border guard has only 12 seconds to make a decision is because we will not accept any slowing down of the processes of crossing borders. The objective of the 21st century is for those of us who are entitled to travel, that we should be able to get through borders as rapidly as possible, and therefore we should not be stopped for anything more than 12 seconds without the infrastructure in the airports, etc., breaking down altogether. But you can read Frontex's own report, which is called 12 Seconds to Decide. So opening up the floor to you. There are lots of experts here who would like to ask anyone a question. You can ask our online, and we have online questions as well. So if you haven't got anything, Martina, I think you're going to have to come up here, or else I'm going to have to repeat every question, right? Because people online are going to, yeah, just tell me and then I'll repeat it.
So I have a question to Petra Marna, but it is also to everyone. So it's specifically to everybody, to the whole panel. And I remember that she started her presentation.
Actually, it's going to be better if you come up in here. I can see this is going to be an important question. Come and speak into the microphone.
I heard when you started the presentation that you referred to, you question whether or not the human rights frame is still sufficient for challenging border violence. And you pointed to the fact that we might want to articulate an abolitionist perspective on technology. So I was wondering specifically to Petra, but to everyone, because in the end, it seems to me now this was not developed in your presentation. What do you have in mind by abolitionist perspective on technology? Given that you mentioned the possibility of repurposing technology, AI in particular, from like controlling, surveilling migrants towards diminishing racism at the border. So I'm wondering in which way we can think about AI as a way for taming racism at the borders, considering that is enshrined in policies that are specifically devised for keeping some people out. And this is a question to everyone. So it seems to me that all your presentation refer to this possibility of either taming, regulating the bad effects of like technologies, or correcting errors, bias, right? Or hinting towards like an abolitionist perspective. So I was wondering if the fact that AI has been, from what you said at least, systematically integrating the borders, push us to basically frame the debate on the desirability of borders around this question of errors, invisibility, privacy. That is also, I mean, in the field of, I don't know, debates on migration is something also quite new, right? That the question of the desirability of borders becomes a question of errors, invisibility, and privacy.
Thank you very much for a super question, and one that, particularly the one to Petra about how do we turn algorithms into mechanisms that root out racism, I think is one I would love to hear the answer to. Who else has a question? Yes, Claudia, and I don't know who you are, but everybody has to come up here so that those online can speak.
So thank you so much for all the papers. I have also a general question, but it was kind of sparked by Petra and then Gavin and Dimitri's paper, and it's around agency, right? So I would like to ask the panelists, I mean, you mentioned the kind of distribution of agency, human and non-human, how you see and where you see this agency, right? And how you think about it. I'm also thinking of, I'm an international relations scholar, so we often think about migrant agency, right? In all of that as well. And then I have another kind of quick question to Gavin and Dimitri. I really love the fact that you focus specifically on a technology. I think it's really important to actually attend to the details and the specificity to avoid some of the hype around AI and so on. But my question is about the relational ontology, and what I thought in the paper, what I thought you did in the paper is something, you know, a move that in a sense Eyal Weizman does as well, right? So law kind of gets incorporated into becomes, right, part of the technology, and therefore is not this outside critical discourse. But I was wondering about the opposite move, right? So in a sense, if the undoing of the law is also made through this kind of private companies, through these technical specifications that already kind of not necessarily use the discourse of the law, but maybe preempt, right? Some of these. So we already have fairness that's already preempted, right? So some of the discourse on bias, we already have optimization. You know, some of the companies now say we are 99.98% accurate, right? So it's very hard to then make the argument this is fair so often. There are so many false positives because they are already doing that. So I'm just wondering about the opposite way, right? So the infra-legalities, in a sense, the infrastructure has already transformed law. So anyway, I'll stop here.
And can I invite you to come up and ask your question?
I wanted to ask a question about the draft EU Act on Artificial Intelligence. And I think this question is probably to Gavin and Dimitri. Do you think this is a new transnational legal instrument, and this can be labeled as a gold standard in the absence of any other comprehensive legal tools at the moment? Thank you.
Thank you very much. Shall I take the online questions and then I'll give everybody a chance to answer and then we'll break? What are the online questions?
Yeah.
Do you want to read out the, oh, right. Okay. There's one question, which is, this is for Nyovi. What if a person has a bad throat? How then does speech recognition work? Then we have, could you share the presentations? Okay, we'll try and share presentations. If there should be a difference when the person given the sample for entry clearance and when he arrives at the border. I'm not quite sure, sample of what exactly.
So
that'll be the
he wants to, Sunil, if I'm pronouncing your name correctly, feel free to take
yes.
the
Yes,
to
yes.
explain your question.
Yeah, my question is like for the entry clearance, if we use someone's voice as a sample and we match it on the border, so if the person has a bad throat on that day, so there might be a case the system rejects that person's. So then how's that cases will be handled? Are there other checks as well, like the retina scan, fingerprint scan? So I think this speech scan or this, speech recognition, it not should be the only one phenomena. It should be combined with other biometric checks. Like if someone wants to eradicate the passport from this world.
Thank you very much. I have a question specifically for Amanda, which is, what do you mean for the operationalization of foreseeability requirements to maintain rule of law safeguards? Could you give an example of what these foreseeability requirements look like in the context of automated risk assessment systems? And I think that's it. So I will hand over, first of all, to our online speakers. Petra, do you want to answer any or all of the questions?
Sure, and I'll be brief because I know that we have limited time. Thank you so much for that question about the abolitionist perspectives and whether the current human rights framings are enough. Here I was alluding to the fact that often, of course, in the human rights framings, we are so centered on the individual, and I think sometimes we forget about the kind of collective impact that these infringements can have, including conversations around collective rights to privacy, as well as different conceptualizations of legal realities that are, being pushed forward by indigenous communities when it comes to land rights and surveillance and things like that. And perhaps also just to bring it back to the ground, for us at the Refugee Law Lab, and also a project that I co-run with Professor Tendai Achiume and a few others called the Migration and Technology Monitor, we're trying to work from these perspectives that foreground not only people's agency, but also working from a more participatory approach where people on the move themselves should really decide what they want to work on, how they want to contest and resist surveillance technology and automation, or whether there are ways to, for example, redistribute resources and power in these spaces so that these technologies can also then become sites of resistance and contestation and creativity. And I think for me, this is all part of the kind of abolitionist framing and a more creative, forward-thinking framing, while of course still recognizing that we live in a very current reality where conversations around current interventions and governance conversations also need to be had. To me, those are not kind of mutually exclusive. I think they're part of the same paradigm. And this is perhaps where that point about the EU AI Act comes in as well. A coalition of civil society organizations, many academics in this room. We've been trying to get policymakers to think about some red lines around border technology and whether there is actually a space in the Act to say, no, we really want to just abolish certain uses of this technology with varying levels of success, of course, because it's a complicated process and migration is always a political issue along various lines that it currently breaks down upon. So I think it's a space to potentially think about just more creative ways of centering lived experience in these spaces too, and opening up opportunities for further conversations. I'll leave it there. Thanks.
Thank you. Thank you very much, Petra. Amanda.
Yes, so I'll answer Katarina's question then. What I mean with the operalization of foreseeability, well, it's basically a word kind of to pinpoint what does foreseeability mean in this context, because I see that if you look at court case, for example, and legislation, you see that what is required, how foreseeable something has to be for the individual is different depending on different legal areas. For example, we had penal law as one example, and border control as an example, where usually not a lot of foreseeability is required by the judiciary, for example. So what I mean is basically to analyze now in this very new context, because we already know foreseeability border control pretty well, but when it's automated, does the same standards still work? Do the court use different standards? And are these good enough to fulfill rule of law requirements and potentially to criticize this? And an example of what this kind of foreseeability requirements can look like in the context of automated risk assessments and how they can be different from the normal context is if you look at, for example, the PNR judgment, the recent one from June. For example, when the court says a lot of things here about foreseeability, but when it comes to, for example, remedies and having access once an individual is challenging an automated processing, maybe because it's discriminatory, for example, the court says that this individual should have access to, for example, the risk criteria underlying the decision once you're in a legal process, but there is exceptions made for when there are cases of threat security, which will be a very big part of these cases, which is one of the things that is the main ground for risk assessments. So this is something that would be something I would discuss here, that, for example, is this standard reasonable when this is all about threats to state security? Who will actually have access to this? And what does this say about the foreseeability in this new automated context? I hope that was an answer to the question.
Thank you very much, Amanda. I think that was very interesting indeed. I'll ask now Dimitri and Gavin to come up and answer as many of the questions as they can.
So maybe I'll start. Yeah, thanks a lot. I mean, picking up on different parts of different questions, and maybe in a certain sense, I think, yeah, well, maybe the AI Act is a good place to start, because it goes in the direction of what you described as this orientation towards error and optimization. So I think this is a trap that is present in a lot of these initiatives. For example, the framing of the inequalities and sort of forms of social classification that are enacted algorithmically, how the inequalities and forms of violence these engender gets reduced to the problem of basically debiasing, right? And I really like the work of someone like Ramon Amaro, who has shown that actually what this often leads to is even more surveillance and inclusion of even more data on people for whom invisibility might actually be the normative aspiration, just in order to get like sort of the polluted data out or to correct the algorithm or clean its correlational machine, while the idea of statistical neutrality remains intact, right? And so, and that is clearly something that you see at work in the AI Act. So its orientation towards non-discrimination, for example, is actually just an orientation towards having traceable sort of transparency and a capacity to reverse engineer the algorithm to then check it for like sort of statistical bias or error. So I think we're really in that kind of normative register. And I think, I mean, I can speak for both of us, but like we believe that to be a very limited one. So it might very well be that the AI Act becomes a gold standard of something, right? And that it has an effect of norm diffusion, but that might not be desirable from our perspective. I mean, from my perspective, at least. And I think that's, Claudia, that's such a great question on the extent to which sort of infrastructures have preempted that. And I think part of how that works out in our like sort of mind at the moment, our mind, it's not like we have like this sort of cybernetic collective mind.
We do on this.
So we speak of the infrastructural Brussels effect. And on the one hand, that seems to be like sort of a story of how norms get infrastructurally spread and then encoded, right? But it works also inversely, right? So the notion of reasonable suspicion in the legal norm becomes substantiated through the infrastructures of risk assessment, right? Is that like, so the algorithms of risk determination now become sort of, they predetermine what that norm actually substantively entails, or they delimit it, like what you mentioned with regards to this focus on fairness. So it's both like how the norms shape the infrastructures, but then it's also maybe more about like sort of how the infrastructures delimit or determine what these norms entail, right?
Yeah, I mean, I'm just picking up on that point. I think, you know, in terms of what is the agency of these kinds of ordering effects? I mean, I think some of the things that we're seeing in the interviews is just how proximity, having BAE data scientists right at the center of the Home Office around this stuff, I think is having an effect on how questions of fairness and bias are even being discussed at a senior policy level. So for example, you know, previously we might have thought of, in my previous life, I challenged the Home Office on, as a lawyer, and in administrative law, it's always about the decision maker taking proper considerations into account and weighing that and so on. Those same decision makers are now talking about accuracy and bias in maintaining a representative data set, which shifts the locus from the decision maker, of course, to the after the event kind of testing of the accuracy of the data. That's just one example of how having BAE at the center of that space is kind of shifting the kind of public law parameters for, and I think one of the arguments we're trying to make is that it's important to look at emergent data infrastructural arrangements precisely because of the regulatory ordering that they're exerting in this space. It's not just that law's outside the arrangement, it's being reshaped. And I think that that's a critical point that we need to take into account. Interestingly, on the question of bias, however, it's being pulled in a different direction. So on the one hand, there's a kind of internal view inside the Home Office that, of course, you know, that just means looking at stop and search data. That means we can't just put garbage in or we'll get garbage out. However, they're also aware that in order to overcome the limitations of a legacy IT infrastructure project, which has been perpetually failing in the Home Office for the last 20 years, it requires enrolling frontline border staff and drawing on their expertise in order to make this program work. I mean, they've been quite clear, I think, in the interviews that what sinks infrastructure projects like this is not human rights critique, but frontline border officers thinking that it's going to take their job and refusing to comply with the terms of the infrastructure delivery project. So to do that, one interesting thing that we're following is you have to kind of enroll those border officers to believe that this system is building on their expertise, which means that the initial formatting and generation of rules for the data set is actually building on those same border force officers. So you've got this kind of, tension here between delivering the project on time and trying to avoid bias in data sets, but at the same time having to build biased data sets by drawing on the frontline border staff in order to enroll them into what does that mean for their role? Well, effectively, they're becoming data annotators because those border force officers, although they're being sold a project of harnessing their expertise, they're also formatting and classifying the training data for machine learning algorithms and models, which will eventually supplant, if not severely augment, their discretion. So there's lots of kind of agential reconfigurations happening around that. Also, what does it mean to move towards an algorithmic model that operates at scale? Particularly, they're also aware that, and of course, although we haven't gone there yet, we're very interested in exploring what kinds of interfaces are being deployed in order to make that scale manageable for the border staff themselves, and how that changes the decision making inside the Home Office. On the question of abolition, I mean, I don't have much to say on that. I mean, from my personal perspective, I think it's important to take these infrastructure projects with a grain of salt. They've been a consistent failure inside the Home Office for the last 20 years, and so it may well fail. We're particularly interested in the productive effects of that failure and how it reconfigures relations inside the state. I'm less convinced by an abolitionist critique, but one of the reasons I'm particularly interested in the socio-technical dimension is because I think it opens up novel lines of critique. So, for example, with increasing private involvement in public decision-making and data sharing, there's going to be new protocols, the use of private contracts and so on, procurement processes in order to facilitate governance arrangements. So it may be that, human rights may be losing valence as a critical norm, but other legal norms like intellectual property, contract, proprietary systems may be possible sites of intervention as well. So,
Okay, I have to go over there. And because I am mindful of the limited time for a break, I will be very brief and say only three things. One is that obviously if voice recognition is not feasible, then other biometric identifiers could be possible, such as facial recognition and fingerprints. So the point is that we're moving towards a multimodal biometric identification, which in itself is problematic from a privacy perspective, because obviously the more data that we collect, the more we formatize the body, the more accurate the identification is. But where is proportionality? So I think that we need to strike the balance, and the balance is not stricken right when we informatize the body too much. With regard to the AI Act and whether it will become the gold standard, absolutely not. By the best it can be is a bronze standard. First of all, because it's not particularly high. It's not as the GDPR, and it's not expected to become as high as the GDPR. And second, because we are quite late in the EU in the game of regulating AI, because China and the US have been more pioneering role. So we are still following. So from that perspective, no. And I fully subscribe that with what Molnar said about how the rules on in relation to migration are particularly disappointing, not least because biometric systems are not included in proposal, and we are struggling already in the coalition to include some biometric systems in as high risk and prohibit emotional recognition, which doesn't seem to happen. And finally, with regard to human agency, I'm sorry to say something on that. What human agency can we talk when there is no consent, or whether if there is consent? Because some of these are for instance, in Germany, voice recognition is based on information of the individual, or some of these technologies are based on the consent of the individual. How can we talk about consent when the foreigners themselves do not really understand what are the error rates? And or if even it's required by law, there is no consent there. So human agency very limited. Where human agency can be is when they find a lawyer and they tell them what is happening, and the lawyer can understand the technology and they can bring cases before the Court of Justice. But that's the lawyer perspective happening in terms of the human agency. And I think I'm going to stop there because we need to have a break.
Let me thank everyone. And to our colleagues online, thank you, everybody. We'll take a break for 10 minutes now. Everybody who's in the room can get a cup of coffee over there. Those who are online, you'll have to go into your own kitchen. And we'll see you back here in 10 minutes. Ask. We can.
Hi, Meltem, can you hear us?
Yeah, I can. Shall I?
Do you have a slide or any
Yes,
PowerPoints?
shall I try to share?
Yeah, please.
Okay. Right. Can you see it?
Yeah, perfect. Yeah.
Okay, I'll stop it now then.
Thank you.
Thank you.
Thank you.
Okay, so are we ready to start? I'm not sure that we are meant to start at 15:45 and we have 2 minutes. I'm meant to start at 15:45. Do we have 2 minutes or are we 3 minutes late? It's fine. We can start. Okay, so we are going to start now. So welcome to the second panel on AI and the future of asylum claims. This is super exciting to me. I'm Claudia Arodau. I'm professor of international politics, so I confess I'm not a lawyer at King's College London, but I'm truly delighted to be here and to meet many of you and to meet the panelists here this afternoon. So we will start with Ludivine Stewart from European University Institute on Asylum Procedures and Data-Driven Algorithms, Quo Vadis Due Process. Over to you for about 15 minutes, right?
Sorry.
The microphone's here, right?
Yes. And I think.
All right. Good afternoon, everyone. My name is Ludivine. I'm a second-year researcher at the EUI. Thank you so much to Dr. Bavula and to Alexandra for this kind invitation. It's really a pleasure to be here. Yeah, this should be. This one? Yeah. All right. So in my presentation, which is very much inspired by my own research, which is about asylum, so the use of AI in asylum process in Europe, I'm going to talk about assessing the use of AI in asylum procedure from the perspective of due process. So, and the background of this is that, as you have seen also already in the previous panel, there is this growing trend of using new technology, including AI, in the field of migration, asylum, and border management. And this trend is also visible in the asylum process. So here on the slide, on the left, you have this report from 2020, which was made by Deloitte, which identified several opportunities to use AI in the asylum process, including, for example, the use of AI to identify vulnerable applicants. But also, already in 2018, and this is a quote from the former vice president of the German Federal Office for Migration and Asylum, which said that AI, so translated from the German, AI is not a future for us, it's already existing practice. I also wanted to set the scene because we've been talking a lot of AI, but we haven't really defined it. This is, as you know, there is an ongoing legislation proposal about the AI Act or the AI Act. And the definition is a bit right now in negotiation. This is the latest stage according to Euractiv, so what have they been said. when we say AI, we don't really mean this, at least in the asylum process. We really mean very narrow AI, we mean weak AI. So it's most of the time it's going to be machine learning. Another question I find quite interesting to start with is why do they turn to? So why do national authorities turn to AI in the first place? Well, again, according to the German Federal Office, AI is supposed to improve data quality. It's supposed also to reduce time-consuming tasks, also to help decision maker. And overall, it's going to help have a faster asylum process. On the other side also, it can reduce errors. And we mentioned already this report made by Deria Oscure in the FR project. Is what is interesting is that we don't seek to automate asylum process so far. There is this reluctance. We really think that, when I say we, I mean the national authorities, they really think that AI could be used to assist decision-making, not to replace it. So we have seen some of the benefits of AI, but at the same time, and as we've seen before, has a lot of important questions. First, should we use AI in the asylum process in the first place? If yes, when should we use it? Also, should the law regulate its use? We're presuming yes as lawyers. And if yes, how? So in the article, I want to take a step back and instead of moving forward, I want to move backward for a second and to look at really the normative framework of procedure. So I'm going to go back on really legal theory of procedural justice. And this being done, I want to use it to assess the use of AI in asylum procedure. So really, I'm not going to answer all the questions. It's more about guiding the reflection on the use of AI in asylum process, especially to understand where the challenges lie. Importantly, because also we have now an emerging legal framework. So this framework can also help us reflect on where can we head after. So therefore, the research question that I have, and this is also a working research question, is what does due process require from procedure? And how can AI in asylum procedure potentially challenge those values? I kind of wanted a neutral. We talked already before about being against the use of technology. For now, I'm neutral. So this would be the structure of the paper. I go very fast. And also, why does it matter? Why due process? Well, maybe this comes as something very obvious, but due process in legal theory really works as a guarantee against the state. It protects individual against abusive exercise of power and arbitrary decision. It also works as a legitimizing function of the state power. And then more specifically in the asylum process, so asylum procedure are not really the topic that we most of the time discuss, but they're still really important because, borrowing the word of Kagan, they are the gateway to protection. So I've been talking a lot about due process, but I haven't talked about the substance. What does it require? Well, going back to legal theory, due process requires first, according to an instrumentalist approach, so really taking procedure as very instrumental, it requires accuracy. Procedure should ensure the correct application of the law to the fact. This seems very obvious, but when we're going to look back at AI, this is actually quite complicated. But also on the other hand, accuracy is not enough. And you also need participation. This is the non-instrumentalist approach. In this context, procedures should ensure the opportunity of individuals subjected to the decision making to influence the process. So now that we have the framework and that we took the step back, we should move forward. And what does it mean when we use AI in the asylum process? Well, first, for accuracy, what is interesting is that on the one hand, AI can really help improve accuracy, can promote the process. However, on the other hand, you also have many challenges ahead. And one of the concern is the potential for errors. What I think is also going to be interesting is also to look at the sources of error, and maybe we can address them, because then we can really unleash the full potential of AI for the process. And in this context, one of the most important, and this is maybe very repetitive for individuals who are really working on AI, but it's the importance of good quality in data sets. This is, however, going to be really tricky in the context of asylum because you're going to need enough data. How do you collect enough data to ensure good systems? If you take back in the introduction, I mentioned from Deloitte the role of AI for vulnerability assessment. How do you collect enough data about refugees that are vulnerable in the first place? I'm really curious, how are we going to make such a system work? But then even if you have a really good system, meaning it's well developed, no obvious errors in the design or development stage, well, it's still a statistical machine. It's not going to predict all the time the truth, if it cannot predict the truth. Another challenge is the bias in the data, which is in turn going to have a biased decision. I'm going to go really quick because there's so much to be said. But what is also interesting is that those errors can happen and they can influence the accuracy of decision making. This is, I think, there's not much to be said here. But then it's also, if they happen, can we rectify them? Can we rectify ex ante the decision making process? And here again, you have many challenges. And even if we manage accuracy, which is one argument to use AI, well, the main message that I want to connect here is that accuracy is not enough. You also need participation, because both accuracy and participation should be promoted in a parallel. Now, according to Galligan, participation supposes at least reasons giving, explanation for an action, an opportunity to be heard. This is quite obvious. But here with AI, we have challenges once again. And one thing is the asymmetry information. For example, NGOs such as EDRI, they have underlined that often migrants are not even giving the information that AI is being used against them. If they don't have this information, they cannot challenge it. This is quite obvious. Even if they have information, even they're being informed that AI is being used in the decision-making process, that means that they're still going to have access, they still need to have access to representation which has sufficient knowledge about AI. And finally, another challenge that is being quite discussed in the general public decision-making is the explainability of decisions. What I wanted to show is in the paper after, and this is still work in progress, is how this can help frame the debate right now on the use of AI in asylum. For example, if you take the proposal for the AI Act, which we discussed a tiny bit before, I don't think that the AI Act is completely bad. I do think it has a very good potential to promote accuracy in decision-making. It does adopt a lot of technical requirements, which will address the errors that I mentioned before. However, it is completely lacking on participation. And this is also reflected in the work of civil society, which is really pushing, as Niovi discussed before. And for example, you have no general right to information. As to the AI liability directive, here you have a potential for participation, but it is only ex post, nothing ex ante. Then you will have to turn to other frameworks to hope to find some safeguards for participation. Maybe we can turn to the Council of Europe. However, it is still very just zero draft convention which was published, so it's still work in process. And for this, I would like to conclude. Thank you so much for your attention. As it is also an opportunity to get feedback, one thing that I really struggled with in my research is to assess when does AI constitute a risk and when it doesn't. For example, the German Federal Office that I mentioned already before is using AI just for their internal management. Does it constitute a risk for refugees and asylum seekers? I don't know. And I would really like to come up with a conceptual framework to assess the risk. When you have a risk or not, and something is on my mind for a lot. So thank you so much.
Thank you so much. Thank you so much, Ludivine. I won't attempt to actually discuss now, though I have some points for you, but I think I'll group them together in the interest of time. So in that sense, I'm going to invite Francesca Palmiotto from the Hertie School Center for Fundamental Rights to talk about automated decisions and procedural fairness, seeking standards for asylum seekers and refugees. Francesca.
My presentation. Yep. Yeah.
Sorry.
Yeah, no problem. Yeah. Okay. Yeah, it's fine. Thank you. Thank you so much. So again, I would really like to thank Niovi and Alexandra for this kind of invitation. I think it's the first time that, since I'm working on this topic specifically, we can really see how our research complements each other. And I think this is really great because we really need to look into every human right and all the process from the border to the decision making. So today I'm going to talk about automated decision and fairness. I will change that and I will see in a while why. Seeking standards for asylum seekers and refugees. So I am working right now, I'm a postdoctoral researcher, and my PhD, which I defended just 2 months ago, was actually focusing on fairness and AI in criminal law. And now I switched the topic. And I think there is also a lot to learn from the differences in how AI is actually not so much used in criminal law compared to the emerging, increasing use of AI in the migration and asylum governance sector. I work at the Center for Fundamental Rights of the Hertie School within the AFAR project, which is led by Professor Catherine Costello. This project has already been mentioned. I would just like to give you some background information. AFAR stands for Algorithmic Fairness for Asylum Seekers and Refugees, and it's a 4-year project funded by the Volkswagen Stiftung, which looks into fairness not only as a legal concept, but we also aim to look into the perception of fairness from the individuals that are impacted by the use of new technologies, asylum seekers, migrants, and refugees. And it's a collaborative project which brings together the Hertie School, the European University Institute, Oxford, Copenhagen, and Zagreb. So this was also mentioned today. I was actually very happy that this was of interest for many of you. This is the report by my colleague, Deria Opskul in Oxford, which is the first AFAR output, where she mapped the uses of new technologies that are currently used in Europe in migration and asylum governance. And when the report was out, what I was very interested in was automated decision-making. And the paper that I am drafting right now, and I'm almost there at the conclusion, actually precisely tries to do what you were asking before, understanding what is automotion in decision-making. How can we conceptualize these new technologies? Because sometimes the developers or people that use these terms that don't really make sense, like automated triage or forecasting. But from a legal perspective, it's kind of hard to understand what is the real impact of these tools on human rights, individual rights. So this is, let's say, what I'm trying to focusing on and conceptualize these systems with legal categories. And I propose, among others, the category of automated evidence, which is what I will focus in this presentation now. So what is the problem? In asylum governance and asylum procedures, decision-making is not fully automated. And by fully automated, I refer mainly to the concept of automated decision-making in Article 22 GDPR, which is very narrow. It considers only decisions that are solely automated. This is not what is happening at the moment. At the moment, what is happening is that automated systems do not take final decisions, but provide new sources of evidence. Let me give you immediately one example. Your phone, Bitte. This was a report by a civil society organization which looked into a widespread practice in Germany, where the BAMF, which is the Minister for Migration,
was basically asking asylum seekers when they arrive at the registration phase to hand over their phone. This phone was then connected to a so-called e-kiosk, which was taking all of these data and generating a report. And this report was used to assess the country of origin. So the moment the asylum seeker was not providing sufficient documentation, then their phone data was used to identify the person. And this was then, this report was inserted into their case file. And then during the decision-making process, the authorities were using this not only to identify the country of origin, but also to assess if the person was lying. So it was used as a tool to assess the reliability of asylum seekers. Let me give you another example, which was also mentioned by Niovi before. Speak up, bitte. These are basically systems based on language recognition, language identification, which are again used in Germany, in particular by BAMF. Sorry for my Germanness, but coming from Berlin, these are cases that I'm really passionate about, and I have the fortune to look into more details since I'm working there. So this is a language identification tool. What does it do? You need to speak or read a sentence, a paragraph, and basically the system understands your language and also your dialect. Also, coming to the question that was written before in the chat, we had the possibility to talk to the company which is developing this system, which is called Nuance. And they basically said that actually this is a type of agnostic biometric identification, which is apparently much, much more accurate than facial recognition. And it works with thresholds. It's just statistics. So even if you have a sore throat, COVID, have a cold, the match maybe will be less accurate, but still it's about threshold. So even if your voice is not so clear, the system will still recognize it according to the company. So again, this was the report was inserted into the case file and then used as evidence into the decision-making process. So what about fairness? This is my dilemma, my question. These are new systems, new sources of evidence that are used where asylum seekers have really not a clear understanding of how they are used. And I think to some extent, also the administrative authorities that are using these. In the case of the mobile phone data analysis, went all the way through the German Federal Administrative Court, and me and Daria actually wrote a blog post on Fefastus blog on this, where we clearly show that the problem was not so much about the law. There was a law there. The problem was that the administrative authorities didn't understand how to apply the law and how to be in compliance with the law, with horrible effects on asylum seekers. So this is my question. When we have new sources of evidence, what about fairness? And in terms of research that has already been done on this, we have on the one hand, of course, scholars we are all familiar with that, of course, raise concerns in terms of automated decision-making and the challenges to procedural rights, non-discrimination, remedies, and so on. So there are concerns there. The problem is that in asylum decision-making, even without automation, there are problems. And I'm referring here to the asylum lottery in Europe, the literature that shows that even if we have clear rules, primary law, secondary law, we still have highly discretionary decision-making in this specific field. So we have this, this is clearly concerning. But on a positive note, we have another strand of scholarship focusing on data processing, data protection, and in particular the GDPR, which shows how the concept of fairness is a key principle of the GDPR. In particular, here I'm referring to Clifford, which states that fairness is a key principle to counteract the power and information asymmetries. And also Malgeri, that shows in his research how fairness in the GDPR is a mitigation of data subjects' vulnerabilities through specific safeguards and measures. So what my research now aims to do is to connect these dots. We have unfairness in automated decision-making, unfairness in asylum decision-making, but some promise in terms of data protection, which of course applies the moment we have automated evidence because it's based on processing of personal data. And finally, another concept which I put a question mark, which is trustworthy AI, which is the concept that we find in the AI Act. And I have a question mark for two reasons. First, because as already emerged today, it is unsure whether the AI Act actually will provide for trustworthy AI systems. But the second question mark is also on what is the relationship between the concept of trustworthiness and fairness. And these are questions that I aim to address. So my paper aims to connect these dots and address the question, do European legal standards foster individual fairness in automated asylum decision-making? Let me first clarify very briefly what do I mean by individual fairness. At the beginning, the title is still the same, procedural fairness, but I actually changed my mind because I think that a more holistic approach is needed here. So by fairness, I mean substantial, procedural, but also in terms of remedies. Automated asylum decision-making, as I said, are mainly referring to automated evidence in administrative decisions, subsequent judicial review, but also withdrawal protection. We've seen in the report many cases where actually these systems are used in return decisions. And what I found extremely worrisome was that the BAMF was using this language recognition system. When Daddy asked them, why are you using them, especially in return decision, they replied saying, well, because the country of origin wants reliable evidence. This was the justification. So they really think that this is a truly accurate, reliable evidence that can also justify return decisions. What do I mean by European legal standards? Here, I think we really see an overlapping of different frameworks. We have, of course, EU fundamental rights. We have EU asylum law, and I'm referring to the qualification directives in terms of rules for evidence in asylum decision-making, but also, of course, the asylum procedure directive. And we have two new entries, let's say, the EU data protection law, which applies, and also to some extent the AI Act. Again, here I'm not using the word AI evidence, I call it automated evidence, just because of this uncertainty in the definition of the AI Act, and because not everything is AI, but still can raise several concerns. So in terms of methods, what I'm trying to do is, first of all, I need to, if I want to understand whether European standards foster fairness, we firstly need to have identify what is the benchmark for such assessment. So conceive fairness as a right and look into EU human rights that apply to asylum procedures. Second, I want to illustrate the challenges that automated decision-making and evidence poses to fairness once I have identified the benchmark. And I would like just to give you a couple of examples. So we are talked a lot about bias and errors, which of course is a problem, but my question would be, who checks whether the system is reliable? Who is legally allowed to do that or has a duty to do that? So this would be my question. Another question that I have in mind is that in asylum decision-making, we have this concept of individual assessment of evidence, which we find in the qualification directive. But at the same time, we use automated systems that work purely on statistics. So there is this mismatch. How can statistical evidence be sufficiently individualized to prove a fact that is relevant for the decision-making? And then finally, in terms also of suitability, which is a part of the proportionality principle. Is a language identification really a suitable mean to identify a person? Question mark. Finally, I will evaluate EU asylum and data protection law, and to some extent also the AI Act, even if of course it's still a proposal, it's still a draft, in relation to fairness in the final part. So in terms of contribution, I think here, this is, you can see it's a very legal doctrinal paper, even though I think it's important to look into empirical studies on the effectiveness of GDPR, because we sometimes think that there's a panacea for all the damages and to correct and protect individual rights against any kind of harm that can be derived from automated systems. but there is literature that actually shows clear problem of enforcement of the GDPR in practice. And I will particularly look into the problems with the right to access. So this paper aims to provide a systematization of overlapping legal standards based, as I said, on legal doctrinal methods, but also on empirical study and empirical research that is out there through constructive frictions among normative sources, which is a term by Professor Catherine Costello. Second, I want to investigate the implications of the general principle of European public and asylum law for new tech. Can they keep up for the new challenges? And finally, one of the aims also of the AFAR project is to be policy driven, to have policy impact. And I believe that this legal doctrinal reconstruction of all these standards can represent a baseline study for advocating reform for fairness. Of course, this is a very, very preliminary research outline, but I think, especially after today, I can surely share some hypotheses that I have, and which I think also the case of mobile phones really showed that on the one hand, there may be some gaps in law, but there are overlapping standards, and even European public standards of administrative law is important to look into their role in the automation age. So I think the problem lies more in the gap between the law and the practice, or at least this was really the case in the mobile phone, cases in Germany. And how can we address this gap between the law and practice? Another problem that I think is extremely relevant is the lack of legal and technical expertise. Even when I have the right to access to my personal data and I can do something about it, maybe I don't even know what to do with it. So we have a lack of technical expertise also with the lawyers that should help. So here we really see it's not just about legal complexity, it's about technical complexity of these systems and how automated evidence can actually be challenged in asylum procedures. So these are just, very preliminary hypotheses, but I believe that a legal doctrinal assessment in this case, it's extremely important and needed. So thank you so much for your attention.
Thank you very much, Francesca. I have a question that's really super interesting, but I'm going to hold back, as I promised, until the end of the panel. So the third speaker who is online is Meltem Inali Sider, and please correct me, Meltem, who will be speaking on AI in the resettlement processes, a discussion on its benefits, risks, and legal consequences. We do have a thread on risk in the panel, so I look forward to hearing more. Can you share?
Right. Thank you very much. I will try to share my screen. Good afternoon, everyone. Thank you, Niavi and Alexandra, for the presentation invitation. It's a pleasure to be here, and apologies for not being able to attend face-to-face to this great event, also being really sick. So I hope to make a coherent presentation, but I may not be able to do those. So today I will use a PowerPoint, hopefully will make my points a bit clearer. So this is my sabbatical project, the AI in resettlement processes. And for those of you who know me before, you know that I mainly work on international European and Turkish asylum and migration law. But AI is quite a new area for me, which I really enjoy to read. And this sabbatical little project of mine builds on actually a very short article published last year about the future of resettlement and the role of AI. And this is supported by EUI and Turkish Science Academy's Young Scientist Awards program. So today I will briefly look at what is resettlement and how it is regulated in international and European Union law to give you a context of what I will be talking about, the potential and existing use of modern technologies in the context of resettlement. And finally, I will try to see or explore some of the risks, benefits, and legal consequences of the use of modern technologies in the context of resettlement. So I'm sure that already in the room and online probably knows, but There is no resettlement definition that applies universally because it is not defined by an international treaty, neither the Refugee Convention nor any other international human rights document. Resettlement involves, according to UNHCR, the selection and transfer of refugees from a state in which they seek protection temporarily. So this can be a transit state or a first country of asylum, to a third state which has agreed to admit them as refugees with permanent residence status. When we look at UNHCR documents, but also UN documents such as the Global Compact on Refugees, we see that resettlement is accepted as a tool for, or promoted as a tool of protection, a solution for refugees, a tool of burden and responsibility sharing, and a demonstration of solidarity. Resettlement is also accepted one of three durable solutions among voluntary repatriation and local integration. So who gets resettled? Traditionally, UNHCR meditates, and it is a key player in resettlement processes. So resettlement targets refugees mainly as defined by the 1951 Convention, and in particular vulnerable individual among the refugees that do not have any other durable solution available to them. So when we look at UNHCR resettlement submission categories, we see that, for instance, women and girls in risk, refugees who may need may have particular health care needs, or those who have a previous case of torture and violence. Those who lack any other foreseeable durable solutions, they can be accepted and selected for resettlement. States are free to determine who to resettle, and although traditionally when UNHCR meditates and be part of the process, this is usually selected among refugees as defined by the Refugee Convention, states are actually quite free to determine who they want to resettle. And when we look at what happens to a resettled refugee, although resettled refugees traditionally get permanent residence or citizenship of the resettlement state, this is again up to the resettlement states which status they will get and the rights they enjoy. So for those of you who may not familiar with the process, first, refugees who fit the UNHCR submission categories are identified, and this can be done by the UNHCR, or this can be done by third NGOs or different actors as well, depending on how resettlement states want the process to be. So, but mainly it works through referral of UNHCR. Once UNHCR select appropriate candidates, they refer these individuals, refugees or refugee families to the resettlement states' national authorities. They select their own criteria, so they might prioritize certain groups over their integration prospects, language, education level, or specific vulnerabilities. So if the resettlement state accepts these refugees or refugee families for resettlement, then the preparation process starts and they're actually transferred to the resettlement states. This is followed by reception and integration processes. So when we look at resettlement and international law, we see that there's actually a gap in international law regarding resettlement of refugees. As I mentioned, the Refugee Convention is quite silent on the different aspects of resettlement, and there is no duty on states to resettle refugees. So there is no right to resettlement in international law. Therefore, states retain competence to decide if, who, and how many persons to resettle. There are divergences between national resettlement process with many regards. And you might think why I am telling you all these about international law framework, because my hypothesis in this paper is that compared to the use of modern technologies, AI and other tools in the context of asylum, my colleagues previously talking before me mentioned that in refugee status determination, for instance, the rules are set mostly by the Refugee Convention, at least who should get the refugee status and which rights should be given to them. In case of resettlement, since there is a gap in international law, states enjoy more freedom to employ modern technologies because, as I mentioned, there is no right to resettlement in international law, and resettlement is just a discretionary act of states to grant durable solutions to refugees. There's also no international convention regulating different aspects, so still states enjoy quite a bit of freedom. And finally, establishing jurisdiction and responsibility of resettlement states, especially with regard to their resettlement selection missions done in the first countries of asylum, is nearly impossible. There's a great article by Deborah and Ziek of 2019 looking at state responsibilities in relation to resettlement, and they also confirm, for instance, for such missions done in first countries of asylum, it is very, very difficult to establish jurisdiction of states, for instance, under the European Convention on Human Rights. So therefore, perhaps modern technologies in resettlement processes, states enjoy much freedom about that. And when we look at how resettlement is regulated under European Union law, this also reflects the realities that I mentioned in international law. EU member states traditionally implement national resettlement programs or ad hoc initiatives. We don't have a unified approach yet, because although there is a 2016 regulation proposal establishing a union resettlement framework, this proposal actually was not adopted. And actually the Permanent Representative Committee Coreper of the European Council of the European Union adopted an amended proposal in December 2022. And when we look at this, we don't know if this proposal is adopted too. It's under negotiation. But what the new amended proposal foresees is that compared to the 2016 proposal, it differentiates between resettlement and humanitarian admission. So resettlement should be based on UNHCR referral, and resettled refugees should be given international protection status, whereas the regulation talks about humanitarian admission, which can be done on referral from UNHCR, EUAA, and other international organizations such as the IOM. And resettled persons within these programs can be given any status, including national humanitarian statuses. And this could be relevant to NIOBI. So the new amended proposal foresees the amendment of the Eurodac regulation to make sure the data of resettled persons, despite the fact that they're not asylum seekers, their data to be stored up to 5 years in the Eurodac system. And finally, it introduces time limits for resettlement procedures, and there is an expedited procedure where AI can be used in the future. And we also see that in eligibility criteria, member states can give preference to those who have a better integration prospect based on social and cultural risks. And there is no right to appeal a negative resettlement decision. So there is a problem about the right to effective remedy, because we do not have a right to effective remedy. And compared to RSD, for instance, due procedural guarantees in the context of resettlement is quite low in practice in general and in the EU legislation, if this proposal is accepted too. So let me come back to my issue. So what are the current uses of AI? And let's start with digitalization, not AI, because this is just a use of modern tools such as this digitalization. We see that with the COVID pandemic, the use of digitalization in the context of resettlement has actually increased. We see that many member states moved their selection missions online. So normally, once the refugees are referred by the UNHCR to many member states, they do selection missions, face-to-face interviews in first countries of asylum, such as Turkey, for instance. But with the COVID pandemic, they started using digital tools such as WebEx and Zoom and Skype. And according to EAA, this didn't result in very effective procedures. That was time-consuming and worse than face-to-face interactions. We also see from the EMN's reports that a new mobile application in Croatia has been piloted. And this is an application which gives free information about integration tools and use of information for resettled refugees on their rights and procedures they need to follow, which is available in many languages. So this is one of the existing digital uses in resettlement. However, when we talk about AI, machine learning, and matching algorithms, we have an existing use, which is piloted in the US and Switzerland. And this is, so the academic works, there are many academics work focusing on if we use a combination of machine learning and optimal matching, for instance, to assign resettled refugees to certain regions and locations in the resettlement states, they might have more chances to be employed and have a better chance for integration. This is Bansak and others' work in 2018. We have other academics working on similar matching systems. So based on this kind of literature, it is reported that academics in the UK, US, and Sweden developed this tool called ANY, and here is you can find their website, which assigns refugees to regions in the resettlement state where they have a better integration prospect based on employment. And this is mentioned that it is applied in the US as a pilot project and yielded quite positive results. It is also mentioned in different literature that Swiss government uses similar software by scientists from University of Stanford to distribute resettled refugees to different cantons in Switzerland, again, based on their integration prospects. So in my paper, and hopefully this will be a first working paper published by the EUI in, I hope, summer, and then article for Niovi and Alexandra's special issue. So I decided to explore the potential use of modern technologies in the context of resettlement into 3 different categories. So the first one is green, because it doesn't really have any international human rights violation potentials, because when we use the AI-based chatbots or virtual assistant to inform the resettlement candidates about the process, their rights, pre-arrival, or as integration tools, as mentioned, for instance, a developed version of what is being used in Croatia after arrival to actually foster integration, this can actually have very few implications in terms of human rights violations. It can also enable resettlement candidates as well as resettled refugees, if they are selected for resettlement, to access better to protection and rights, and this can increase their access to information. So there is no risk in that, as I see it. So this is the safest way to use AI in the context of resettlement. What is I want to add to, and this is quite adding, it can have serious risks and in human rights violation potential, is the use of AI-based tools in conducting eligibility and exclusion assessments for resettlement. So when AI tools are used to actually render a decision on the resettlement, so giving someone saying that you're not vulnerable enough to be resettled, or you do not exactly fit the criteria by the resettlement state, if this decision is solely and only left to the AI decision making, this can have serious implications. I corresponded with UNHCR offices in different places, and they said they have no plans to use AI in the context of resettlement selection procedures for now. Which is good. But at the same time, I think this can be experimented by member states which conduct their own resettlement missions, or to select from refugees referred to them by UNHCR. So when we talk about eligibility assessment, we talk about eligibility for refugee status, eligibility for vulnerability assessment, or assessment based on whether a refugee fits the definition of the resettlement state, for instance, integration prospects, so on and so forth, but also exclusion assessment, which usually includes security checks. So if AI is used in these contexts, I think it might lead to perhaps faster decision-making, enable high volume of applications to be decided in a faster manner and quicker manner, but depending on the role of AI in these processes and the involvement of the end user, they might be quite big risks. And this is mentioned in the first panel by Niovi and other presenters also in this session. Lack of transparency when machine learning is used, for instance, how a person is rejected for resettlement. We do not know, so this really harms the due process rights. This can increase bias in decision-making depending on the data set or which algorithms do or will it be used. It can also violate equality and non-discrimination principles. And since, for instance, in the EU, resettled refugees data is to be seen to be shared in the Eurodac database, the right to data protection and privacy issues might arise, especially thinking that resettled refugees are quite vulnerable in a sense that they are the vulnerable community among the refugees. So this might entail risks. And here we have somewhere in the middle, which does not create perhaps major human rights problems, the use of matching algorithms for refugees to foster integration prospects, although it does not present major human rights problems, as pointed out by Petra, who spoke in the first panel, and Jill in their publication. The use of such systems can exacerbate inequalities by placing refugees with the least prospect of success into under-resourced areas, because if you do not have, for instance, employment prospect, if you do not know many languages, you will be sent to the poorest or areas in the resettlement state where you will not have much employment future or prospects. So this is also important in that sense. So when we look at these and explore the use of AI in 3 different settings, we see different levels of risks being engaged. But at the same time, I wish to conclude perhaps that there are the risk and the benefits depend on the role of AI in the decision making in relation to the resettlement processes, and there is a need for research when such systems will be actually used. So thank you very much, and thanks for listening.
Yeah, there is a no foreseeability. No comments from the online audience.
Okay. So we are gonna check, but so one of these first kind of cross-cutting points that came across to me, and this was particularly in Ludivina's and actually Francesca's paper, was this question of risk, right? And you're asking, you know, how do we assess risk? And of course, we have whole professions that just do the risk management, right? They kind of know very well how to assess risk, and they do it particularly, for example, in relation to likelihood and impact, often in kind of impact of destruction and so on. But I think what's important to kind of bear in mind when you think about risk is that I think it's a kind of, I would say it's a slippery slope, and I'm going to kind of try to say why. Partly because risk itself is a way of governing populations, right? So this kind of calculation and management is a way of governing, and it's a way of governing these technologies and a way of governing the people who will be governed themselves by these technologies. And in that sense, you know, it is tempting, but I think it kind of leads to an exercise where these questions of likelihood and impact would lead to questions about who is the most vulnerable, right? And we kind of risk kind of getting into that logic of dividing populations and thinking, how will these populations how will populations to be resettled be affected more than the refugee population? Then, you know, so we kind of enter this exercise where we start looking for the most vulnerable. So, I mean, the EU Act is using that, but it is exactly because it's a way of governing these technologies rather than asking the questions of, you know, what the border do or the kind of, you know, forms of oppression and power that people encounter at the border and what to do about that. This is, you know, I think to me, it's an interesting question in relation to law. The second question that's perhaps related to I think it is related to the first panel, and a kind of a relation between the first panel and the second panel, and it links to Alexandra and Ismini's like latest point about, you know, how do you think about law in this kind of socio-technical context. It seems to me there are 2 kind of understandings of law that cut across and they don't meet, and I was wondering in terms of the lawyers in the room how you think about them. So it's kind of law as somehow exterior that kind of gives us the norms and vocabularies and the language and therefore governs, right, and kind of governs in a kind of regulatory restrictive way these technologies. And the other approach that I think came across in the first panel is the more socio-legal law itself as being part of this assemblage and therefore being already entwined. Now, the reason I'm asking, I think it's really important to think about, you know, these vocabularies of law as not kind of being exterior, but being always in translation with vocabularies of AI, computer science, and so on, is because I thought that, and this is particularly to Ludivina and Francesca again, that the vocabularies that you're using, but again, we saw them across accuracy, fairness, explainability, have already been tackled both by the computer science, right, but also by the private industry, in the sense in which we have a whole field of research on algorithmic fairness that has been doing this. They've given the answers, right? So they are already producing these technologies that kind of pursue the rules of algorithmic fairness. Similarly, we have explainable AI. So they've already kind of given us the technologies to kind of have explainability. And similarly, they've already kind of developed the debiasing. I mean, you know, has the whole question of that not being enough. The fourth question is about actually what AI is. And it seemed to me that we have a whole range of technologies, right? From statistics to digitization to machine learning. And I was wondering how important it is for you to actually talk about the specificities of particular technologies, right? Because I think it makes a difference if we talk about statistical profiling, population profiling, or if we talk about machine learning, data mining. I think that would make a difference. Right, but also partly because there are many debates about AI hype, and we have seen even the Financial Times kind of told us that a lot of the companies use AI as a kind of way of gathering, kind of getting funding, but not actually, it's not AI, right? So the question of what AI is here, I think it could be quite interesting. And final question is about how AI works, right? So there's an assumption that, and I wonder whether it's shared, that a lot of the analysis, it seems to me, in law focus on this assumption that it works and therefore it does these things. But again, as we heard about the Home Office, we have 20 years of failure, right? So what happens when it doesn't work, or, it is kind of productive through its failure? How do we deal then with those questions, right? Or kind of assuming that this technology doesn't work as well. And I'll have a specific question for Meltem, and then I'll sit down and see if anyone has any other questions from Meltem, so that, it's 5 o'clock. Meltem, I'm going to stop here and actually ask you if you want to say something about risk at all, or if you want to pick up on any of these points.
Right. Thank you very much, Claudia. I think your points were very interesting, and you're true. We, like, for instance, benefits risk and potential human rights violations, we see that in EU documents a lot, EU white papers and AI documents, but we need to perhaps delve into what does really mean. And when risk, because I'm a lawyer, I'm always reminded of potential violations of human rights. Therefore, I think it's important to, as you mentioned, identify what is risk, but at the same time, for me, it's to what extent a rule or a use of AI, for instance, can violate international human rights principles. Thank you.
Excellent. Thank you very much. Does anyone else have any questions for Meltem? I know you need to leave in 1 minute. I'm just kind of looking. Sure. Okay. Meltem, at the moment, there are no questions, but if I may just very quickly, you might need to leave. I want to raise it's also around risk and the chatbots and the kind of information, the virtual assistant. So in my own experience, actually they bear risks, partly because often they are not updated. I've seen this also in my research on apps for refugees that contain information. So they actually often contain outdated information. They require continuous work to be updated. You know that a lot of the asylum legislation, guidelines, and so on change all the time, right? So therefore, the risk is kind of emergent through this technology. So just a small point that actually, if we apply this kind of thinking around risk, we can see chatbots and virtual AIs. In a sense, there's no technology that's risk-free because there's no such thing as zero risk. So all of these technologies will have some risks. Does anyone have, now that I've kind of, because I did a whole kind of spiel for a long time, so I want to look at you. Do you have any questions for, okay, excellent, for the panel, Anna.
So I'm going to use a word that you use on this slide, which is AI to improve accuracy. And then I wonder, which kind of accuracy and whose accuracy? Because these algorithms rely on historical data of asylum offices. Then is AI improving the accuracy of historical oppression of the asylum system? And for instance, 98% of people from Senegal that claim asylum in Spain is rejected. So do we want an AI to reinforce these statistics and mechanisms of historical oppression? Is AI and algorithm discriminating, or rather centuries of border and historical infrastructure of oppression towards people in the move?
That's a very, very, very good question.
Sorry.
Okay, can I just cut in? I'm really sorry, but I need to leave now. Thank you for the comments, Claudia. I think I will look into that. I'm still writing that section of the paper, so it was very useful. Thank you very much. Thank you very much for the whole panel and then those listen. Thanks a lot. I need to leave now.
Thank you,
Sorry. Bye, and
Get
hope
well
to see
soon.
you. Yes,
Bye.
soon. Bye. Thank you very much. Bye.
Okay. Okay. Anna, sorry, I forgot that. So my question was, so I was using a quote on the slides which say AI to improve accuracy, and I was wondering whose accuracy, because these algorithms rely on historical data of asylum offices. Then is AI improving the accuracy of historical oppression of the asylum system? And then I give an example of, for instance, in Spain, 98% of people that come from Senegal and claim asylum in this country is rejected. So do we want an AI to reinforce the statistics and mechanisms of historical oppression? Is AI and algorithms discriminating, or rather centuries of borders as historical infrastructure of oppression towards people on the move? Thank you. Thank you, Anna. Shall we collect? So I think Martina also had a question, and I'm just looking, Martina and Gavin, sorry, you need to kind of do the tour of all that.
So I have a question to Ismini Alexandra. Thanks a lot for your presentation. And in your presentation, you stressed this, the importance of rethinking the principle of non-refoulement in light of this non-Westphalian understanding of borders, right? Enactment of borders. But I was wondering how this is also, meaning there is a longer process that that is also grounded in the use of the law, or better, the systematic governing of migration on the margin of the law. And what I have in mind is, for instance, in the EU Pact on Migration and Asylum, the very concept of fiction of non-entry, right, is a way for, I mean, not only, it's not about deterritorializing the borders, but producing this fiction, right, of when the person is inside the country or is outside, irrespective of the physical presence. I was wondering also about the role of the law itself in producing these, and not just the technology that, the use of the technology that breached the law, right? And I'm wondering if the use of AI is part of this more structural way of governing migrants on the margin of the law. So that is not fully legal, but is and the second question, yeah, is kind of related to what also Anna asked, is about what if we start from not the invisibility, but actually the even more blatant visibility of laws that are used within the politics of asylum for preventively excluding migrants, not only for rejecting migrants to get the asylum, the refugee status, but to be eligible. No, and this is what is also going on in Greece, or also what might happen in the UK. So that is so blatant and is so visibly now put in the law, even if this law is partly legal, that that some people won't be even allowed to claim asylum.
Thank you. So Gavin and Dimitri. Okay. The cognitive assessment.
Thank you very much. It's to all of the panelists. My question is to Ismina and also to Alexandra. And I'm really interested in the paper. I know it's the end of the day and we may not have time to do that, but it's an invitation to really unpack and say more about how you propose to develop a theory of digital non-refoulement on the basis of your empirical research. That that mismatch between the kind of Westphalian ordering and the kind of the forms of displaced global assemblages that bordering practices enact is a productive mismatch as far as states are concerned. And we've seen that in every example, from the Snowden revelations and the global surveillance regime that was articulated there to different forms of migration management. So how do you propose to develop such a theory, to move from an empirical understanding or a socio-legal understanding of infrastructural practice to the development of some kind of digital theory of digital reform? I'm interested how you make that move. Is it around empirically studying the particular justifications that states use when, or others use when these mismatches arrive between Westphalian ordering and algorithmic practices, or through some other means. So yeah, it was just an invitation, a request to find out more. Thanks.
Yeah, I also had a, I mean, it was also related to the talk by Alexandra and Ismini, but without, I mean, not to overburden you and open it up a bit. I think it also maybe links with the idea of the concept of, how was it phrased? The normative constructive friction among normative sources, what you mentioned, the quotes, I think might relate to that too. And it links with the notion of, so you work with territory and Westphalian territory, right? But in a certain sense, and that's like sort of very delineated as you describe, and it's this mismatch with the digital border. But in fact, I suppose maybe in a way you're speaking about the alignment of territory and jurisdiction, or like, and the jurisdictional element is I mean, it's of course territorial as well, and we might think of like sort of jurisdiction as equally delineated, but it is of course already sort of an abstraction from that materiality of territory. And I'm just thinking in that relation how you work with concepts like this notion that Violetta developed around functional jurisdiction, or what Itamar Mann calls like this human rights encounter, and in a certain sense how the jurisdictional can maybe sort of harbor these like sort of the fungibility of the digital maybe more appropriately than the territorial, and ultimately non-refoulement would also be connected to the jurisdictional maybe more than to the territorial. So I mean, just to bring that other concept in and what it does. But I mean, I really enjoyed it, so thank you.
Thank you very much. I think we have quite a lot of questions, so maybe we can do a round of answers, if that's okay, starting in the same order.
Yes, first of all, thank you so much for your points. I will take them home with me, because it already gave me some ideas where to explore. Yes, so now turning to your question, as regard accuracy, it's really the criteria is about the application of the law to the substantive fact. So very simply in this case, I would say who should be refugee according to the law should be refugee. And then is also going back to your question about how to look at the application of how AI is being used. You really need to look then how AI is being used, because at the same time I say that AI has the potential to increase accuracy, to actually confer that, make sure that individual who would qualify as asylum, so as refugee, would get to refugee status. This is maybe AI can help, because also we know one problem is the bias, and work is now being done on where if AI can actually help see where bias is in decision making, that would help, in my opinion. Then, as the researcher also say that there's tons of problems again with AI. Really what I'm trying to do is I really want to take them as objective. They're never going to be achieved. You're never going to have a perfect procedure. You're never going to have perfect accuracy. But it's, I don't know, it's, at the same time, AI has so many problems, but I don't want to say AI is, you should completely always ban AI, because maybe it can actually help. And yes, this is also something I'm still trying to figure out when and how.
Implemented for like asylum procedures, but for instance, if you rely on past data, all Ukrainians couldn't apply or would have like a rejection, because in the past, like, you know, where they would come into Europe, they never claim asylum, right? So then the algorithm would say like, relying on the past data, these people should be rejected. So, you know, because there are also like these shifts in the world, in the content. So
yeah,
it's also like another way of like seeing how AI could be problematic, a part of like, or how states instrumentalize technology and also like the asylum procedures based on nationalities.
But then, for example, here it could be, it's a technical problem, because the data teams, because I think it's called data drift, something. It's also, for example, for social, not for, it's In the context of banking, it can happen. For example, when you had the COVID, then all their systems completely, they didn't work anymore because of this external factor. But then maybe you have a technical solution that actually you just update your system. If I'm not a data scientist. Of course.
States decided to which nationality they accept an asylum case.
But this you can also visualize. You can try to visualize your data. You have steps. You do have some technical solutions that can be done. For example, when you have a bias in data, you can visualize your data. You can do a statistical review. Again, not a data scientist, but you have some steps to visualize if you have a bias in your system.
For me, like I'm a computer scientist, so for me it goes beyond the bias on the data. It goes like on the way that states discriminate asylum seekers, asylum applications through like nationality, based on nationalities. And you have the statistics there. You can see, like, for instance, in Spain, people that come from Senegal, they have like an 98% of like rejection, but people that come from Venezuela, they have like
but like, but they can sleep. People online can't hear you, so that's why I have to. Yeah, I'm still sorry about that. They can't hear. So, Francesca.
Yeah, maybe. Yeah.
You need to come here. Sorry, otherwise it doesn't work. And I keep forgetting.
Now, a quick point on technical solutions, since we are talking about it, to recall also what you said at the beginning, and then I give the floor to Alexandra, who had more questions. What you said about algorithmic fairness and literature, technical literature, computer science literature on explainability, fairness metrics, and so on. I think it's extremely important to have an interdisciplinary conversation about these topics. I think this is extremely key. And that's why I'm not a big fan of this trend of literature, because it's only computer scientists, most of them. And I'm not sure all the time that these are solutions, in the sense that we have a clear mismatch between, again, it's about terminology, right? Like, bias is not necessarily discrimination in a legal sense. Explainability is not a justification or a reasoned decision in a legal sense. So these are where all my question marks are, and also what other scholars are also saying, that, okay, you know, AI poses a problem, it gives a solution, but not all the time. For example, explainability means necessarily fits the requirements of a justification from a legal point of view. And then I think sometimes we don't even need necessarily technical solution. I think, for example, the case that today was largely mentioned, Ligue des Droits, in front of the CJEU, I think that's a great case, especially when it looks into effective remedies, because what the court is saying is not the system should be explainable. What the court says in an administrative decision, it is the duty for the authorities to ensure that the person understands the program and the criteria. And then in judicial review, it is important and crucial that the person has the right to examine the criteria and the operations of the program. So this is really deriving from legal concepts. It's not even a technical solution, I don't even know how to say, it's a requirement for this whole transparency. It's disclosure of information. So still, however, I think it's extremely important to have an interdisciplinary conversation and have also not a common vocabulary, but just be clear about what do you mean by bias and what do I mean as a lawyer by discrimination? What do I mean by fairness? Algorithmic fairness is surely not procedural fairness as I think about it from a legal perspective. It's something completely different. And we really need to have a conversation where we don't necessarily come up with a new vocabulary, but at least we are very clear about definition and we avoid misconceptions. So that, yeah.
Thank you, Francesca. Sandra.
So, Ismene, would you like to start? No, we cannot hear you. You're muted.
Okay. I think you can hear me now, right?
Yes.
Okay. So I'm going to start with Martina's question because it's actually exactly what we're trying to do, your question. So it was very interesting. That's exactly what the concept of digital refoulement is practices that are so much on the verge of the law that they are actually illegal. but the line is so thin to demonstrate, like from a legal perspective, how illegal they are, and then from a technical perspective, of course, in which ways they are illegal and in which ways these systems work. So yes, it is very much a non-entree practices, like you mentioned, the practices of non-entry, let's say, are very much related, because Eurosur, for example, and systems that aim to conduct extraterritorial surveillance, in the end, function as non-entree tools. So this can be very much related to refoulement. So this is exactly the point that we are trying to make, that it is not so much on the verge of the law, but it is rather outside the realm of the law. But it really is a very thin line to prove it. I think we can do it, but we're still working on it. And then how it affects the asylum procedure, like up to now, from what we have discussed and from what we have read, I believe, and I think Alexandra shares this viewpoint, but of course she can add more if she wants, that mainly it affects the asylum procedure in the sense, firstly, that the obvious sense that if someone is prevented from entering based on all those systems and their functions, they lose basically the right to asylum. So following that, if they do manage to enter, and then we talk about things happening within the territory, let's say, it can happen, but then we wouldn't talk about AI so much, at least for now. We would talk more about other types of digital systems. Like I have done some work and have studied quite a few cases of when in Greece, for example, during the asylum procedure, before the interviewer takes a decision, they have to quote the tools that led them to their decision in order to decide whether the interviewee, let's say, what they say is accurate or inaccurate. In order to do that, they use digital tools, but that's not in the realm of AI, because I have seen like cases being rejected based on like Wikipedia articles. So it is a question of how the technology can contribute towards, let's say, rejection of asylum applications, but it's not so much, it's not at all an AI thing. So those are basically the two things I can think of on the top of my head. But it's also because, as Alex said before, the systems are not operating yet. So we will have to, unfortunately, let's say, wait and see for in which other ways it might affect asylum procedures from now on.
And are you finished? Would you
think
like to say something?
I might
Okay.
add something again.
Yeah. If you want to say it now.
Maybe you go
No,
ahead,
okay.
Alexandra.
Building on Ismini's answer, that was actually the reason why we went for a reconceptualization that in a legal perspective can be a bit radical, because we were trying actually to bring together what social theorists and social scholarship says about where the border is, and then try to link it to the very strict legal understanding. And it is indeed, that's what we aim to unpack, the nexus between territory, jurisdiction as power, and the effects of and technology. And we're still working on it, but that is why we went for a more radical reconceptualization. We think that the concept of functional jurisdiction still has some limitations. And about Gavin's point, I think it's a very big discussion. We can discuss later. That's all for me. So, yeah.
Yeah, so I don't know, Ismin, I think now we are meant to actually, we are supposed to round up the panel. Oh, Niovi, this is perfect timing, because I think we can round out the panel unless, Ismini, you have something that you very quickly would like to add so that we can turn to Niovi to wrap up the day.
No, I think we should, I mean, just a very, very small contribution. I wanted to talk about the case law and say that even the conservative case law of the ECHR has recognized occasionally some cases of extraterritorial jurisdiction in cases of refoulement. So maybe we will find a way via the case law as well, or I'm confident that we will, to fund this idea of digital refoulement. That's all. Sorry.
Thank you.
Thank you so much.
Thank you to all
I
of you.
think these two panels have brought out many different perspectives on the use of AI and the challenges it poses from our fundamental rights, procedural, substantive, rule of law. And the interesting thing is that it's not territorially restricted. We see challenges, from national perspectives, regional perspectives, international law. So we are in this boat all together, I would say. Some of us are trying to fight, some of them trying to regulate. Anyway, I appreciate that we are past our time and everyone is very tired and hungry or thirsty. And therefore, I will not say much. I would say that I will follow up to the authors for the special issue with regard to the procedures, the deadlines. You already know them, but we will push a bit when the time comes. To those of you who participate online or in person, we hope that this workshop had provided you some food for thought. It opened up new possibilities for further research. And as a personal note, for someone who has been working on this for more than 10 years, it is fantastic to have so many people finally interested in migration technology. It took 10 years, but it finally happened to actually have this kind of event solely on these topics and not peripherally on migration technology. So I don't feel anymore as a loner in this journey. So thank you very much. Alexandra, do you want to say anything as well? No? Okay. Then, without further ado, we thank you, everyone. We will stop recording now, and we hope to see you in another one of our events in the Border Center or the Human Law Center, to which we are thankful for their contribution and support, and somewhere globally to continue our exchanges on these very interesting topics that are bound to preoccupy us in the next years. So, bye-bye. Have a good evening, everyone. Thank you.